Common matter, man. Common matter.
Suspension matter, the petitioner suspend near about 4 years, but till today not released the suspension allows. This was Monday.
Matter of 2021 pleading is completed and it is illegal regarding illegal termination. Next week, because it is petition superior is approaching.
I don't mention my letter.
Three times I have mentioned it 2022 matter. Will also directed after 2 weeks, but it is not come.
Post it after 2 weeks.
I don't mention my letter. I don't mention it. Due to the interim order passed by the Hon'Ble court, my lord, interim order recruitment process has been stalled, my lord. Your lordship yesterday.
But it's not
Recruitment process, my lord.
in TGT Hindi में लड़
started. Yesterday, your lordship modified this matter.
same process.
I'll take no tomorrow, my lord. Jo Monday, my lord.
one matter.
Same matter.
My matter is
Modification of the order. Your lordship order that is in case of opposite part number 2, it has been reflected opposite part number 3. Take that.
I don't mention my lord. My lord, earlier this matter was listed on
what you want.
My lord, here my lord.
What you want.
My lord for
Posting.
yes, my lord. My lord, it can 25. It can be disposed of, my lord. It is a matter where the name of the father of the petitioner has been changed and it was been also notified in a gazette notification, my lord.
My lord, this matter in view of the urgency, I request for listing of the matter on Monday, my lord.
What is the urgency?
Urgency is this petitioner is a lady who has been working as a peon since 2007, being appointed against rehabilitation.
Where is the urgency?
Urgency is they are trying to now post her as sweeper and asking her to join within 1 day.
RSP matter. Question 635 adjournment by the Hon'Ble Court. October 2nd week.
October 2nd.
But not tested. Fix up not listed in October 2nd week. Adjournment slap on October 2nd week.
October 2nd week. It has not come.
My lord, RSP matter. My lord, RSP matter, my lord. After completion 30 years service, not the petition not comply the RSP third RSP, my lord. After completion
28.
Regarding the area dues and other government dues, my lord, is pending.
My lord, the BMC, the Bhubaneswar Municipal Corporation matter unauthorized held of 41 lakhs rupees of the petitioner.
First week of.
My lord, matter
First week of. Second week of law.
Matter relates to lordship. Matter relates to regularization fresh matter, your lordship.
Fresh matter.
May I please, your lordship?
To the second week of law. Yes.
My lordship, matter related to promotion.
Promotion.
Lordship, this matter was specifically adjourned to 28th of August. After that also we have filed one memo. Still now not listed, your lordship.
First week of law.
I don't think there is an urgency because the petitioner is the student of 9th standard. Now what happened? The principal is forcing to use their second language as the Odia.
Tuesday.
No, lordship, the identical
Tuesday.
Lordship, last date is the registration of the 10th standard, my lord, 13th of this month. Identical matter has been put to also 30th.
Which date it is posted?
13/10/2025.
From 13.
My lord, this is a fresh admission matter, UGC scale of pay, and in similarly covered matter, notice has been issued.
Notice has been issued.
Kindly this be taken on Monday.
Oh, what is the urgency for that?
Because
We'll have it on 28th of October. Yes.
Pardon to mention, make a mention, Your Lordship. Lordship, the urgency in this case is that the recruitment.
Why are you weeping? Be bold.
Lordship, the recruitment process is already over. And the career assessment mark of the petitioner has been wrongly calculated. If it is not calculated properly, then Lordship, the remaining seats will be abolished.
All right, Tuesday.
Grateful.
I will pardon my lord. Item 17. Item 17.
17.
Kindly taken up next week.
17 to be taken up next week.
Yes, sir.
Which year?
25.
Week after next.
Next.
My lord, item 59, my lord.
59.
The Kendriya Vidyalaya matters,
Which year?
2025. I am for the OP1 and 4. Today filing count. Copies are my lord. Senior appearing for opposite man.
Petition council was trying for.
I am consent, already consent, my lord.
From the petition council. I am for the Kendriya Vidyalaya, Raj Your Lordship.
But
You want to file counter in course of day and want to.
15th, my lord. 15th, 1-5.
15.
The interim order to be continued.
That's
Yes.
my.
Yeah.
Item 29, my lord. Can you post it to next week, my lord?
29.
Yes, ma'am. Item
You want next week?
Yes, ma'am.
Next week we have difficulty, brother. Can you have it the week after next? Yes.
Presence in 59, item 59, my presence for the Kendriya Vidyalaya may be noted, my lord.
Council, panel council. Vidyalaya. It's not
God bless.
1 and 4, my lord.
Yes, brother.
Item number 1. Item number 1. Doing old matter, my lord. In fact, this matter came up in the supplementary list. Yesterday, I told you.
You use this mic or that mic. Do not stand in between these two. Yeah.
My lord, this is concerning settlement of a piece of land, which admittedly was belonging to government, belongs to government, and the land is in occupation since the time of the father of the present petitioner, my lord. So in 1967, there was an encroachment proceeding against them. That encroachment proceeding continued because they were in possession of a government land. Therefore, the matter was proceeded. But during pendency of the encroachment case, my lord, settlement operation came into force. By the time the settlement operation came into force, the father of the present petitioner had died, but notice was issued in his name. Therefore, this son appeared, the present petitioner appeared, and he filed his objection. The objection was while being heard, my lord. In the meantime, since the father had died, the encroachment proceeding was dropped. Since the father of the present petitioner had died, the encroachment proceeding, which was initiated way back in 1967, that was dropped finally because he was dead.
Suppose if robbery happens and the robber dies, the right to recover the robbed item also dies.
No. I don't say so. This is a fact which is I have brought to record. Because the person against whom the encroachment proceeding was going on, the Tahsildar said he is dead, so it was dropped. But the fact remains, Lord, in the during the major settlement operation, Lord, though the objection was filed by the present petitioner, being in possession since the time of their father, Lord, the objection proceeding was, Lord, disposed of by directing forcible possession in respect of one of the plots from out of the 3 plots which were in possession. And the plot, admittedly, is a Nozul plot, Lord, under the Sabiq record, which the present petitioner have been occupying.
How much land extent is what?
Lord, land extension is
10 days.
Yes, 13, 42, and 10.
What?
10, 13, and 42.
Total is 10.
The extent of land is not 52 plus 13.
That means 64. So 65 decimals.
65 decimals.
You will alter law, I can understand, but you cannot alter the mathematics. Yes.
So 65 decimals total, not 65 decimals of land.
65, what is the unit it is? Acres, guntas, cents, what is that?
No, here decimal.
Here it is
Decimal.
Here it is decimal.
How much it is?
It is per 1 gunt. It is 4 decimal. In somewhere it is 40 unit. So it is 63, 65. 65 come to
16.
100 decimal is 1.
Guntas it will be. 16 gunta plus 1 decimal.
No, 40.
16 into 4 is 64, na? Plus 1, 65 you say. So 4 guntas, or 16 guntas, plus 1 decimal.
1 acre is 100 decimal.
1 acre is 100 decimal.
1 acre is 100.
That way. Okay. So one decimal is 1 cent. 100 cents equal to 1 acre. Okay. Anyway, for me to understand.
So therefore,
needs vary, na?
after disposal of this, after the completion of this settlement operation, my lord, since the petitioner by his own conduct, my lord, he did not prefer an appeal. He could have against the order of passed in the objection case. He did not prefer an appeal or in a revision also.
Correct.
Therefore, my lord, when there was a threat of disposition, they approached this honorable court in 97. So there was a direction that don't dispose them without following the due process of law. Then the matter stood as it is. Then, Lord, this petition was filed for seeking settlement of the land on the ground that the land which was admittedly a nozzle plot, which can be settled under the provisions of the OGLS Act.
Which is that section?
Now, so we'll see section 3.
3. Which act? Which section?
Yes. Of the OGLS Act.
Full name of the act?
Orissa Government Land Settlement Act.
Oh, there is such a statute?
Yes.
Okay. I did not.
So I pass on this.
To whom it applies? To which land it applies?
Landless persons and homesteadless persons. And there are categories of land which can be settled, provided they are in possession 3 successive years prior to date of appointment. That is not coming into force of this act. Lord.
That act came into force when?
This act came into force in Lord 62. This provision, in fact, has come by virtue of Lord, an amendment brought in 1991. This was inserted.
1991.
Yes.
How it reads?
Lord, I'm just coming, Lord. Yes, Lord. Your Lordship will find section 3, reservation and settlement of government land. Lord, section 3, subsection 4. So first, your Lordship will section 3.3. The settlement of land under this section shall be made in the following order of priority, namely cooperative farming societies formed by landless agricultural laborers, any landless agricultural laborer of the village in which the land is situated, or any neighboring village, ex-servicemen, members of the armed forces, ryots who are personally cultivating not more than 1 standard of land, and so and so, so and so. But this was in existence. Now, thereafter, Lord, we see
in which category you fall.
Well, I fall into the category of Lord. I'm just placing you. Yes, but I am who is it is belong with the person. The transferable right with the person who is in occupation of such land either on the basis of a lease or otherwise for a period of at least 3 years prior to the appointed date.
Lease or otherwise?
Otherwise.
Means what?
Supposing he has gone unauthorizedly, he has occupied though, but land is not objectionable so far as he is seeking, he is a landless person, he can prove that he has no other patch of land.
I am asking a question. The word otherwise is preceded by the word lease. That has been interpreted by various high courts. Lease or otherwise means in any way whatsoever is not the meaning. The word lease will cast its shadow on the word otherwise by virtue of the maxim nocitur e socis. First time you are hearing it, perhaps.
Yes.
Nocitur e socis means the meaning of the word depends upon the company of other words. Like if you say, you tell me who are your friends, I will tell you who you are. Similarly, if words are used in a group, the meaning of each word will have some attraction to the meaning of other words. That way, that is called nocitur e socis, Broom's legal maxims. There is a famous book, Broom's legal maxims. About 50, 60 editions it has seen. Unless you read such books, where is the quality? How quality will come to the bar? Quality will run away. These are your instruments. The instruments of agriculturists. Have you ever seen any agriculturist going to land without instrument? No. But why lawyers come to court without instruments? With the assumption that the judge will till the land. I will not till. Read best books. That helps your language. That helps your knowledge of law. That gives a strong stead to argue with force. Otherwise, 2, 3 mics I have to put in front of you. With all inferiority complex, you will argue. That's not a good thing. You should argue with superiority complex. That superiority comes only by studies, nothing else. There is no substitute. And what you are doing is called in Sanskrit, Yuddha Kale Shastrabhyase. During war time, war is declared. All right, you start the drill now. No, drill has to be done continuously.
So at this moment, my lord, just I wanted to convey to my lord that matter came up in the supplementary yesterday, my lord. I was not the conducting counsel, in fact, lord. Yes. Though I have the power in this case, and in the meantime,
now what should be done in the matter? Years have lapsed now.
I know. I wanted just 7 days time. That is next Friday, till next Friday, and that is an order. Your lordship may kindly have a look to that order. Order number 12, dated 7/4/1998.
7/4/98.
Yes, ma'am. Order number 12.
Yes, Brother Mohanty, the order says to ascertain whether they are still in the occupation of the land or not. What your officers have told you.
No, my lord.
You also compete with your friend.
No instruction. As of now, because it is of 98.
I'll call this matter on Monday. Tuesday. Because 98, I cannot give time because we have seen what the apex court said.
Can it be Thursday? By that, in the meantime,
Thursday,
I will have the breathing time.
All right. How your father gained entry to this land? Number 1. When your father died, thereafter, who continued in the occupation of the land? What is the evidentiary material? These are factual matters. What is your right to get the land or remain on the land? That's the question of law. In both these terms, you have to come with preparation. Government land, there is a famous statement by Hugo Grotius in his famous book, De Jure et Pacis, the law of the seas. He said, that belongs to none, belongs to all. That belongs to all, belongs to none. Means government land will continue to be government land. Individual cannot claim. Anyway, you started studying here only. Yeah, I'll give you time, don't worry. On Thursday, you come with preparation.
Yes. Right. I'm sorry, my lord. I actually, my lord, showed a wrong provision. That provision, in fact, is section 4, section 3, subsection 4.
Anyway, you read, keep that act on my table. I'll also come with preparation. I And do not mistake me for telling you to read the books again and again, because books are your instruments. Is it? Have you ever seen Baba Sahib Ambedkar photograph without a book? Always with a book. That is how the lawyer should be. Yes.
Item number 2. Regulation of Gana Shikshak is a regular private teacher.
Item number 2.
Yes, ma'am.
Gana Shikshak.
Yes.
Regularization.
Yes.
We have issued notice in many matters, no?
Yes, similar matter notice has been issued.
Any representation you have given?
Yeah, no, my lord.
Because that disease has come to me also after seeing so many judgments.
Notice.
Yes, issue notice. Here, Mr. Mohanty, AGA accepts notice for the OPs. All private, no private party.
No, my lord.
No, my lord. 1, 2, 3, all are government.
All are government. Obvious.
Item 3.
Yes, sir.
These are my that Sarath Parida, that matter notice has been issued in the similar matter. And Hemant Sotray, both the matters have been heard by the division bench.
Division bench.
Notice will be issued here.
Mohanty accepts notice. No private party. Wherever there is a private party, you have to tell me.
Exactly.
Next.
Item 4. Ballot.
I have not presented Miller.
What is that? I have issued notice now.
No, Miller, I want to stay order also.
You want to interim order?
Yes.
What is the
the petitioner is a proprietorship concern and engaged in manufacturing utensils.
It is a matter. This is 3, my lord. Item
number 3. Now. Okay.
This is 3.
Lordship calls item 3.
Yes, 3. What has happened, brother?
My lord, the petitioner is a small scale industry, my lord. And he has approached the IDCO, the opposite party number 1, for allotment of plot in the industrial estate Karuga in the district Sundargarh, Raurkela, my lord. And the opposite party number 2, on behalf of the opposite party number 1, he executed the agreement which is annexure number 1, my lord. And the land was allotted for a period of 53 years, my lord. And they received the premium, my lord. And as per the terms, my lord,
within what period you were supposed to establish the industry?
First, within 6 months, you have to start construction, then commercial production within 3 years, my lord. And
what have you done?
Yes. And immediately after taking possession of the plot, my lord, immediately construction was started. The boundary
when possession was taken?
When possession was given, my lord, the allotted, my lord. And the possession was running page number 29, my lord.
I am asking the date, not page number.
Well, possession was given on 8/4/2021, my lord. 8/4/2021, my lord.
7/10/2021 will be 6 months.
6 months, my lord.
What did you do?
Yes, my lord. After taking physical possession, my lord. Immediately.
You want to argue?
My brother is there.
Lord, may kindly see the agreement. Page 17.
Yes.
E is there. What is the consequence, my lord, if within 6 months the construction will not be there?
Yes.
Lord, may kindly see page 17. Clause E. The licensee shall have to start civil construction on the allotted property within 6 months.
You have not done that.
My lord,
I have read that.
Yes.
Therefore I must.
Yes. From the
Still able to read.
No, my lord, what is the consequence? From the date of possession and commence academic session, commercial production within 3 years from the date of handing over possession. The extension of implementation up to 1 year may be allowed without imposition of penalty, provided the licensor is convinced that the delay is not due to the fault of the licensee.
Correct. It becomes 2 years.
1 year.
3 + 1.
My lord.
Yes.
However, penalty at the rate of 1% of prevailing land cost of the industrial estate shall be imposed beyond the approved implementation period at the discretion of the licensee. So only penalty of 1% has to be levied.
Yeah.
But he can cancel it. The license cannot be cancelled. So this is the clause which
provided you show the reason.
Yes, I have shown. My father was suffering from cancer.
During what period she was suffering from cancer?
You lords may kindly see this. I have given the explanation.
Yes. Show that. Give the proof also.
My lord, the first, my lord, notice to show cause was given under Annex 2. I had given, my lord, you lordship may kindly see Annex 3. I had started construction. There is no dispute that I have not constructed. I have started construction. I have made boundary wall. I have made a gate. Therein, I have constructed a gate. I mean, everything I have constructed. I have started construction. But though my father suffered from cancer and he expired under treatment while he was under treatment at Bombay, my lord, that is the reason I had so. You lordship may kindly see page 31. I have said.
Where is the photograph?
फोटोग्राफ अपना नेक्स्ट फोन नहीं अपना बैठ दोनों ने फोटोग्राफ सो दी फोटोग्राफ you lordship may kindly see I have stated therein that after taking
I have read that already. After reading it, I am asking you because you have referred to the photograph. Do you have photographs now?
Yes, yes.
Give that. Just give it all right as it is. Just I want to look in. The client should not suffer for ill pleadings. You have put up construction now?
Yes.
What is that industry you want to establish?
Utensils manufacturing.
Huh?
Utensil manufacturing. Utensil manufacturing.
Issue emergent notice. Next, petitioner has moved an application for interdicting coercive action pursuant to impugned order. First, counsel for the petitioner, at the instance of the court, has placed on record the photostat copies of color photographs, which arguably show that some construction has already been done. He also tells that whatever legal delay has been accomplished, has been proved, is because of father's illness, into bracket, cancer. How is the father now?
Expired.
Which eventually resulted into his demise. First of all. Next paragraph. A prima facie case is made out for granting interim protection, and therefore application having been favored, application supported by affidavit having been favored, come up. Status quo with regard to possession of the subject plot is directed. Till next then. Yes.
Urgent certificate.
Both are brothers.
Item 4.
The matter is regarding to pension of block grant Sarat.
For my lord, does that
Similar.
Similar.
notice?
Yeah, notice. Both the accepts notice.
Item 5.
Matter is regarding sanction of pension, my lord. That is that the petitioner was a teacher.
In 2012, he retired.
2012.
Till date not given.
Till not.
Any reason is given.
Reason during his employment, he was convicted. He was facing a criminal trial.
For which offense?
304 part 1.
304 part 1. Due to negligent act.
No, my lord, it is 302, 323 and
302.
323 and
Under 304
conviction was under 304 part 1.
Part 1.
Part 1.
Then what happened to
prefers the appeal before this honorable court. The pendency of the proceeding is no bar for release of pension. I am relying upon the decision.
Where is the pendency? There is conviction already.
The conviction, the continuation of appeal is the continuation of the proceeding below.
The conviction is not suspended. See that, which is that famous judgment. Sidhu, the batsman.
No.
Sidhu versus Delhi development, which is that. Take out that judgment.
No.
Law has developed. Thereafter, many other judgments have come.
Yes, Lord.
Once convicted, the doctrine of innocence is not applicable.
Yes.
Merely because you have filed appeal, that does not automatically result into suspension of the conviction.
Conviction has not attained its finality.
No, it has attained finally. Unless set aside. That's what Apex Court has said. Which is that judgment. Can anybody take out any instance? Sidhu versus so and so. No case made out. If you succeed in appeal, then you can go before them. Not otherwise. Your idea of criminal jurisprudence is not correct. With due respect, you are senior to me. But as a judge, I have to tell the truth.
The latest judgment is.
There is one famous judgment by Justice K.T. Thomas. Justice K.T. Thomas judgment, which says, once a person is convicted and matter is put in appeal, conviction is not suspended unless the order is obtained at the hands of the appellate authority, appellate body, appellate court. That's the law.
Yes, yes.
Therefore, no case now. What I will do is I will reserve liberty and you can revive your request depending upon the outcome of the criminal appeal. Mr. G, that appears to be the correct position.
Yes.
Take out that Sidhu's judgment. We do not have good. Whoever gives that judgment, one interim order would be granted. This is how I have to work now. Take out. The short grievance of the petitioner is as to non-sanctioning of pension despite his retirement way back in the year 2012. Kindly be seated.
Yes.
Kindly sit down.
I will provide.
No, Basanto. Basanto. Learned counsel for the petitioner, in all fairness, submits that his client suffered an order of conviction and sentence for offence inter alia punishable under section 304B, part 1 of IPC 1860, and that presently his appeal against the same is pending before the division bench.
Yes, ma'am.
Division bench of this court. First off. Next paragraph. Further, he submits that. That's right. See, Navjot Singh Sidhu versus. Check that. Navjot Singh Sidhu versus so and so.
State of Punjab.
State of Punjab. You are right.
2018.
But no interim order to you because after I found it, you have said. Okay.
2007.
Further submits that. Since appeal is continuation of the original proceeding, the pension cannot, the terminal benefits of the convict cannot be withheld. First, next paragraph. Mr. Mohanty appearing for OPs. Presses into service the Apex Court decision in Navjot Singh Sidhu versus State of Punjab to contend that merely because an appeal is filed against conviction and sentence, there is no suspension of the same unless specifically ordered, and therefore no relief can be granted to the petitioner who is a convicted criminal as on this day, notwithstanding pendency of the appeal. First, there is force in this submission. First, next, in the above circumstances, petition is liable to be rejected, and accordingly it is, reserving liberty to the petitioner to revive His request for release of the pension, claim for release of the pension, in the event he emerges victorious in the criminal appeal. Unblemished. First.
Item 6.
This one person is a background teacher has paid to grant a pension benefits as per decision of Hemant Sotra.
That notice.
Take notice. Next.
Item 7.
This matter is relating to librarian's scale of pay. Yesterday, in a similar matter item number 13, the same order may be passed in this.
Yesterday's serial number 30. 18. You have given the representation. Brother, have you given the representation annexure 14?
Yes, my lord. So the representation was in the
14.
December 2023.
Date alone changes, okay? That's 4/12/2023. Annexure 14. All right. Next.
They are in fresh representation was directed because not available.
Just show me it.
Here it is pending since 23 million.
Item 8.
Yeah. That is the matter. Construction of road.
This is a. They are saying it is the construction over by the opposite party. So representation is there, my lord, before the authority concerned.
In their land, they have constructed, encroached.
Yes, my lord. They are challenging the eviction.
Go for a suit, na?
They have filed the representation before the
representation.
Superintendent engineer. Hon'Ble.
The grievance of the petitioner is reflected in the prayer column, as also in the representation dated 25/7/2025 at annexure 5. First, that relates to alleged encroachment of their private property. First, if a decision is taken on the subject representation by the jurisdictional authorities, justice would be done to the petitioner. First, next paragraph. In the above circumstances, petition is disposed of. Which OP to consider?
OP number 3.
Not 3. The jurisdictional 2. OP number 2. Petition is disposed of, directing OP number 2 to take a call on the subject representation within a period of 8 weeks. First off, open to solicit, grounds kept open. Next.
Item 9.
Registry to send a copy of this order to private respondent. Speed first immediately. Yes. Sir, question, what is this?
Item 9, they having the qualification of OTT. Here notice ought to be issued.
Rehabilitation. He has given a representation, perhaps. See that whether representation is there. For granting appointment, in keeping in view the judgment of the apex court. Office order dated 5/11/2024.
5/11.
That is rejected, no? Accept
it is by virtue of the order of annexure 10, my lord, that notification.
Take notice. Accept no. Next.
Item 10.
Yes, sir.
Matter of regulation of Ganashikhat minor. Already similar matter. Yesterday, item now 9 was.
Item number 9.
Yesterday.
What order we have made?
Issue notice.
Notice.
Notice. Any private party?
No matter. All matters are identical.
Same. All along with each other. Yes.
Item 11.
My lord,
yes.
The case for proper calculation of UGC scale of pay of her late husband, my lord, without any discrimination with that of demonstrators of the Utkal University and non-government colleges, my lord. In spite of that, the OP issued a letter that differential as per annexure 2, my lord, differential amount found negative, that is 64,421, my lord. I have challenged that letter.
Matter had come yesterday.
Yes, there are two other matters also.
Two other matters also.
Yes, I am giving the number.
Yes, Mr. Lenka, accepts notice for OPs. Whether already recovery is done now?
No, no recovery. He has already, overpayment has already been made.
So you want to recover that now?
No, no, we have not
initiated any.
Yes.
Why madam is here?
She has challenged, your lordship, page 27, annexure 2. Page 27, she has challenged that order issued by the principal. That is under challenge.
So excess amount they have said now.
Yes.
You accept notice?
Yes.
Lenka accepts notice.
One IA is filed not to operate that letter till disposal of the case, my lord.
The impugned order is staged till the next date of hearing.
In the impugned order, the willingness of the yes, actually.
Question of stay will not arise. No, that may have suppose a date bar, etc. may happen.
No, nothing will happen. She has already taken the excess amount.
Let us see, let him file objection, then we will consider your IA.
Yes.
Item 12.
12, both the cases are similar as that of item number 11, my lord.
They are like 11. 12, 11 together. Same order. Yes.
Item 13. 13 case relates to regularization. Similar matter, your lordship issue notice of the same establishment.
Issue notice, like accept notice, call along with WP number.
Copy has been sought.
Intimate is there?
No interest, your lordship. Copy I have also sought.
Yes.
Item 14.
You appear for?
University. The name has
Sorry. Same order.
Same order. His name has already been reflected in that order.
State is opposite 3 and 4. State is opposite party 3 and 4.
3 and 4.
Yes.
Item 14.
Follow along with.
My lord,
Similar to 11.
my lord, this is a claim of UGC scale of pay. The applicant was working as a demonstrator community college and retired from the service 31/3/2013, my lord. And several identical cases they have complied, my lord. And representation is pending as per annexure 4, my lord.
Consider the representation. Grievance of the petitioner is as to non-consideration of his representation. His or her?
Yes, ma'am.
His representation, wherein he has sought for a particular UGC pay scale, having retired from service, although first off, Mr. Lenka submits that he would instruct the jurisdictional OPs to take a call on the subject representation, a copy whereof avails at annexure
4, my lord.
Annexure 4. Representation dated at annexure 4. In accordance with law, if all contentions are kept open. First, counsel for the petitioner is agreeable with the said proposal. Next, in the above circumstances, petition is disposed of 8 weeks. Contentions kept open to solicit. No force. Okay.
Item 15.
Yes.
Against the rejection order.
Yes, this case, yes. Against the order of rejection. In a similar case, the benefit has been extended. The self-same ground, this honorable court directed to consider the case, but has been rejected on the ground of delay. And delay, so far the employees are concerned, it is recurring. So far the delay cannot be ground at all. And in the similar identical cases, they have already extended that benefit that I have enclosed. They have ignored that.
You take the notice and file short objections. When God submits.
Item 16.
Other vice chancellor is also there.
Yes,
Then notice to vice chancellor.
But item system, my lord.
That is OP1 and
1 and 2.
Yes.
Notice 2 and 3. Emergent notice 2 and 3. Okay.
Yes, yes. You put the inverse.
Yes. Next.
Item 16. My lord, item 16, my lord. Under Annexure 1, page 11. The Government of Orissa School and Mass Education Department issued a circular notification to consolidate the schools and under school and mass education. Had issued notification number so and so for this government school with suboptimal development consolidated with nearby schools through transparent and participatory process. The government had decided to merge the school with low grade of average percentage, my lord.
Your representation is for restoration of peace.
My lord.
Let them consider.
My lord, after passing of the order, my lord, under Annexure 1, so many of the schools have challenged the notification before this Hon'Ble Court. Have a glance to Annexure 3, my lord. The government of Orissa, this Hon'Ble Court, will have a relevant part, page 19. Since the notification dated 5465 dated 11/3/2020 and subsequent order 5538 of 11/3/2020, Annexure 1 the order by pursuant to the notification, those notifications has already been cancelled. First, and the opposite party are directed to restore back the position of the school and question as before, as provided necessary infrastructure for smooth running of the school. I have also approached this Hon'Ble Court, and this Hon'Ble Court has passed this order. This order has not till yet been implemented, my lord.
Why, brother?
Hello?
You accept notice.
I will accept it.
You tell the next day.
Already 5 years gone regarding merger of it. Because of less student strength, the government took a policy decision to merge the school with another nearby school.
The rate appeal पर allow है rate appeal stands in favor of the government.
Yes.
So I take notice of
Policy has failed to accept notice. That like to accept notice. In short point is involved for this matter in this second week of now.
Item 18.
Material area salary. The similar matter already issued notice, man.
Same order. Yes.
Item 19.
19 regarding the MSV matter, similar matter has already been disposed of.
Disposed of. Yes. Take it. Who appears for the OP? It's like yes. Same. Both the matters.
Both of them.
Disposed of.
Item 20.
My lord, regularization of the petitioner is from the date of initial appointment, while juniors are now regularized from initial date
of 9/3/2000, it should be 2/5/85.
I have made a representation before the authority.
Where is that?
That is Annexure 5 series.
Petition prayer reads as that. First one. Counsel for the petitioner draws attention of the court to the representation of his client made to the government seeking alteration of date of regularization. Go to prayer. From 9/3/2000 to 2/5/1985. That is the date of initial appointment. First up, counsel submits that the representation having not been considered, his client is knocking at the door of the court. Next one. Mr. Lenka appearing for the, who appears? G or Lenka?
No, Mr.
Lenka appearing for the OPs. 1 and 2 submits that essentially the decision has to be taken by a respondent in the OP numbers 3 and 4. And therefore,
but he had made representation before OP1.
OP1 and OP3.
OP3.
Both.
Page 26.
3 is also there.
Yes, you are.
First one. Be that as it may. Justice of the case warrants that a decision be issued, a direction be issued to OP numbers 1, 3, and 4 to cause consideration of subject representation within a reasonable time and in accordance with law. First one. Next paragraph. In the above circumstance, petition is disposed of, directing OP numbers 1, 3, and 4 to cause consideration of the subject representation in accordance with law within an outer limit of 3 months. First off, all contentions of the parties are kept open. We just need to send a copy of this order to OP numbers 3 and 4 by speed post.
Item 21.
Excuse me, Lord. In this case, the petition for the villagers of Panas, a sub-health center has to be established in their village. Accordingly, notice was issued by the collector by Annexure 1.
Protect the health sub-center.
My Lord. The Tahsildar has also selected the place that is running page 12 in.
Where is your representation?
In Annexure 5.
But the representation doesn't carry any debt. That's why.
Therefore, no decision is taken on this. You should have mentioned that whichever date they have given it, that will be the relevant date. Essential grievance of the petitioner is reflected in the prayer column, which is as under. Next paragraph. Learned counsel for the petitioner submits that though the jurisdictional Tahsildar has recommended case of his client, no decision has been taken on the representation of the villagers at Annexure 5. Annexure 5. First. 5, and therefore this court should be reviewed. Next paragraph. Learned AGM Mr. G, appearing for the OPs, submits that no proof of sending representation is placed on record, and further that the subject representation is undated apparently. First off, in reply, counsel for the petitioner submits that his client should submit one more representation with supportive material. First off. Next part, in the above circumstances, petition is disposed of, reserving liberty to the petitioners to make appropriate representation once again, along with the vouching material. 7. Within 2 weeks, you make that. Within 3 weeks. Within 2 weeks. Within 2 weeks. 7. If one is made, which OP?
OP number 2, my Lord.
OP number 2 to consider the same after soliciting necessary information from all concerned in that regard, within an outer limit of 8 weeks. First, all contentions of the parties are kept open. Next, no course.
Item 22.
I will plead your lordship.
Yes.
This is an opportunity to appeal for lordship.
Yes, sir.
It's a small matter. The petition of lordship is a producer which was working under the State Council of Education, Research and Training.
Sanctioning of pay scale.
Pay scale rejected. Therefore, I'm praying that let notice go and I will see that because the government has been, this honorable court has already taken notice, nothing can be turned to. Base notice has it.
No, I agree with your proposal to issue notice. Issue emergent notice. Mr. G accepts notice for OPs. Since a short point is involved on this matter in the 3rd week of November.
Item 23.
In this case, the petitioner is a lady who seeks her caste certificate should be granted in the as per the caste of her mother, my Lord. fact remains is that now mother is a scheduled caste, but father is a general caste. After the
Mother is a scheduled caste. Father is a
general caste.
What Madhuri Patil says, caste of the child will be that of the father.
Father.
Unless otherwise, there is one judgment which differentiates that. I don't remember the name of the judgment. That says how child is brought up.
My lord.
In what atmosphere it is brought up.
Yes.
That will decide caste of the child.
In 2013 or 14
Correct.
something
2012 it came.
Yes.
That judgment. But you have to make an application, consent application to the father.
He has not made party to the father even.
Father predicament of the petitioner is that while she was 4 to 6 years old, from that date the father has left to the mother, and whereabout of the father is still not known. So the child has been born and brought up with his maternal uncle and with his maternal uncle, and she.
You should stop after making one statement, because all the statements, these are all pregnant statements. They will have children, sometimes twins in the body. Therefore, you have to stop and say that the child is brought up by whom?
By his uncle, grandfather, that is mother's father, and mother and child all are staying with their
matrimonial house.
Maternal house.
But for that, you have to make an application to whom?
They have to Tahsildar. I had applied to Tahsildar for certificate, but Tahsildar has cancelled that.
Cancel the certificate.
Certificate on
the ground that you do not belong to that caste.
Category.
Because Madhuri Patil says the caste of the child is caste of the father.
My lord.
And how Tahsildar has considered, approached the matter?
My lordship may
take notice and file objections. Issue emergent notice. Next.
Item 24. Yes, my lord. Yes, my lord. One legal error appeal is pending before sub-collector of Bhubaneswar, who is the opposite party number 3. That legal error appeal case, kindly glance to Annexure 8. Order passed on dated 20/2024. The respondent number 9 is present, filing with the objection petition. Also advocate for the respondent number 2, 3, 4, 5, 6, 7.
You want your appeal to be disposed of?
Disposed of this hearing stage re ବର୍ତ୍ତମାନ 10 ମାସ କେସ୍ ଗଡ଼ିଲାଣି, hearing ହେଇପାରୁନି, speed disposal ପାଇଁ prayer କରୁଛି.
We directed the consideration of the appeal in time bound way.
Yes.
Yeah. The short grievance of the petitioner is as to long pendency of the legal error appeal case number 1 of 2024, arising from E-LHC stroke 2022 stroke 148789. First, counsel for the petitioner submits that right to speedy remedy being a constitutional guarantee, appeal of the kind cannot be kept pending for long. Next one. Learned AGA Mr. G opposes the petition, contending that appeal is of the year 2004 to 2024, and that there are many older matters pending on the file of the jurisdictional authority, who happens to be ex officio holder of several positions under several statutes, and therefore petitioner should be asked to wait till his turn comes in the queue. First, having so contended, he agrees with the suggestion of this court to instruct OP number 3 to hear and dispose of the appeal as expeditiously as possible. First of all. Next paragraph. In the above circumstances, petition is disposed of with a direction to OP number 3 to hear and dispose of the appeal within an outer limits of 6 months. First, all intentions of the parties are kept open. Registry to send a copy of this order to private respondent. Any private respondent? Yes. Private respondent number 5-11.
While disposing before hearing of the appeal, he must have given his.
We will make that instead of this.
Yes.
It hardly needs to be stated that the appeal shall be heard after giving an opportunity of hearing to the stakeholders, including the private respondents here.
Yes.
Then we
Pardon me, my lords.
Yes.
All the opposite party already filed their written statements.
Therefore, we have told they should be heard and disposed of.
Item 25.
Your Lordship, if I may.
Yes, Dr.
Your Lordship, in this case, the petitioner had purchased a piece of land in Shyam Sundarpur, Your Lordship.
You want allotment of the plot?
Yes, Your Lordship. So, town planning scheme is backed by the BDA. The petitioner
Let
has.
notice go.
Yes, Your Lordship.
Let notice go.
Your Lordship.
Will issue notice.
Yes, Your
All right. Issue notice. Mr. G accept notice for one. Emergent notice to 2.
BDA, they have got a separate set of.
That's what. Next.
Item 26.
Who, my lord, in the earlier case, notice be issued to them, their private parties, separate set of lawyers they were engaged. BDA, Bhubaneswar Development.
Yeah, second, OP number 2. Yes, OP number 2, notice.
Yes.
Okay. Yes.
Item 26.
The petitioner is a retired teacher. He retired from service on 31/1/2013. But his grievance is that he has been sanctioned
unutilized leave
cycle for 218 days instead of 278 days. Your Lordship may kindly see the communication made by the district education officer under Annexure 2 to the headmistress. And the headmistress has already submitted all the records.
2 months salary is not considered.
Yes. I have made a representation under Annexure 5 also.
Short grievance of the petitioner is reflected in the representation they state 12/5/2020 be seated.
Yes.
12/5/2025 a copy whereof avails at Annexure 5. First, petitioner has sought for sanctioning and release of unutilized leave salary for 278 days instead of 218 days. As the headmistress of the subject school has already recommended,
has already submitted the
requisite documents and records in that connection, while letter number 9895 dated 28/10/2024 issued by the additional district education officer with Jajpur. First half. Next paragraph. Learned counsel for the petitioner submits that the said representation is still pending consideration and that there is no guarantee that any decision would be taken thereon in the near future. And therefore, this court should intervene. First, next paragraph. Learned the AGA, Mr. G, fairly agrees with the suggestion of this court that OP number 3 has to take a call on the subject representation station. First off, he enters a caveat that all contention should be kept open and a reasonable period be prescribed for taking the decision. First off, with this proposal, counsel for the petitioner is agreeable. Next paragraph. In the above circumstances, which can be disposed of 8 weeks, solicit, no cost, contentions kept open. Yes.
Item 27.
Your Lordship. The petitioner is a retired junior clerk of high school, retired since 30th June 2017. His prayer for grant of financial benefit under the RSP scheme has been rejected.
That is rejected now.
Yes, my lord. On the ground that
you take notice.
Yes.
The other matters are for all. Other connected matters do you have?
No,
Item 28.
ମୋର 54 ଅଛି ମୁଁ ଟିକେ ଚାହା ପିଇ ଦେଇକି ଆସୁଛି।
May I please, Your Honor?
Yes, sister.
This is the second round litigation. Here the petitioner challenges the rejection order passed by the opposite party under Annexure 7, Your Lordship.
It is now rejected.
Your Lordship, under Annexure 7, she applied for post of teacher.
Hindi teacher.
Your Lordship, Hindi teacher.
Take notice, Mr. Bhatt.
My lord.
Your Lordship, my application, I have filed an application, application for reserving one post till the.
My lords, in fact, the reason is given, she has not qualified. That is why she was.
Here the main.
So subject to result, your lordship.
Your Lordship.
Counsel for the petitioner submits that an application supported by affidavit by the IA number so and so has been moved. And in terms of that, one post be kept vacant so that in the event our client succeeds, he can be accommodated. First. Learned AGA Mr. Behura very fairly opposes the application, very fairly submitting that. Any selection and appointment would be subject to list pendants, and therefore no relief, no interim relief now be granted. First, there is forcible submission. Next part, in the above circumstances, the application is disposed of, making it very clear that any selection and appointment shall be subject to outcome of the petition. Okay. Next.
Item 30.
30. Ready. That 11,82,000 sanctioned by director.
I have not gone through file, my lord.
Unpaid salary.
My lord, so that
notice.
Lordship, representation is pending.
Consider that representation.
My lord.
Petitioner's prayer is as and done. First, counsel for the petitioner draws attention of the court to the representation dated. How big representations? No longer than our constitution. Dated 5/8/2025. A copy whereof avails at Annexure 7. First, he tells the court that unless a direction is issued, the representation would continue to be pending throughout. First, next paragraph. Learned AGA, Mr. Behura, appearing for the OPs, although initially opposed the petition, now agrees to instruct OP number.
OP number.
DU.
Director.
DU, my lord. I have given representation to the DU.
OP number.
Director.
He has given representation to OP number 3.
OP number 3 to look into the grievance of the petitioner in a time-bound way if all contentions are kept open. First, with this proposal, counsel for the petitioner is agreeable. Next paragraph. In the above circumstances, petition is disposed of. Direction to 3, 8 weeks. All contentions kept open. Yes, next.
Item 31.
31.
May I please?
You have res judicata. You can't appear twice. Yes.
Here your petitioner appears.
Consider representation.
Your Lordship, under Annexure 8, she has been selected for the post of teacher, but inadvertently it has been mentioned as trained teacher. So she did not join because by the time she was an untrained teacher, and the advertisement was for the selection of trained teacher as well as untrained teacher. Your Lordship.
So you have given the representation, they have not considered.
Your Lordship, that is my.
We will direct them to consider.
Your Lordship.
Just can you sit down?
Your Lordship.
Can you sit down so that I will give the dictation? Yes. Short prayer of the petitioner is as and next paragraph. Before making the prayer, before approaching the court, petitioner had sent 2 representations dated 13/9/2023 and 16/7/2025, respectively at annexures, just look into them. 8 series. 8 series. You can say at 8 series. First off, counsel for the petitioner points out that the subject advertisement related to both trained and untrained Hindi teacher, Hindi teachers, and there being some misconstruction. Come on. The representation of the petitioner, that is client, her client, ought to have been considered within a reasonable time. First off, she further tells the court that unless the direction is issued, come on, no decision would be taken on the subject representations. First, next one, Mr. Behura, appearing for the OPs in all fairness, agrees with the suggestion of this court that
representation may be given.
Subject representations shall meet their fate at the hands of OP number. Which OP? Sit down and say, which OP? OP number 2. OP number 2. Within a reasonable time. Full stop. He also states that if a fresh representation is given, that would become handy for taking the decision expeditiously. First, with this proposal, counsel for the petitioner is agreed. Next one. In the above circumstances, petition is disposed of, reserving liberty to the petitioner to make a fresh representation with vouching material within a period of 2 weeks. And if one is made, the jurisdictional OP shall take the call on that within an outer limit of 8 weeks. But all contentions kept open to solicit. No cost.
Item 32. My lord, before I start 32, my lord, 30, item 30, my lord, dispose it of directing the authorities to take that representation. But that is a leave encasement. Correct. Is not giving that person because that DO person of my lord have directed that to consider the representation. I have retired since 31/5/24. 1 year has been passed. And the judgment of my lords are very clear on the leave. I am getting pension, other benefits, retired benefit. It is only leave encasement for no reason he is withholding. But law is otherwise, my lord.
In 30.
Again?
30.
30, man.
30 way of disposal.
My lord said representation that may not suffice the purpose of the claim. That is my plight, my lord. If my lord may consider.
What
because that DO is direct, my lord have directed that DO to consider my representation. He is not, I have grievances against that person only. He is not, I am getting pension, I am getting everything, man. Now only leave encasement, it has been withheld, 300 days. Bill has been there, bill is there, he has sent it, but still he is not releasing it. Government has sanctioned.
How much time we have given to consider? 8 weeks.
8 weeks.
We'll give 4 weeks. And if they do not do, move an application for recalling that order.
Well,
all right.
Well,
make it 4 weeks. Yeah. So that it will come before me only.
That is my. And with all these judgments, I have got also one of my lord's judgment there, not my lord, but of my lord's that Kannada High Court. There they settle the cost also. Well, in this case, my lord, this is the petitioner service was terminated. He was before my lord. It was set aside. And I was directed to be reinstated in service. But now what they are doing, though I have been allowed to join, my past service has been wiped out. I joined on 2/4/2018. It was a 2/4/18.
They are considering it as fresh service.
Now, that is why, my lord, because I am to be regularized on completion of 6 years. This was Sikha Sahib. Otherwise now, my lord, from today, again 6 years I am to serve. That is my advancement. That is rejected.
Terminated?
That they say I was unauthorized absent, but because I was ailing and I have filed the documents that I was medically admitted to hospital and all these things. That was taken note of, and it's the exhaustive judgment of my lord. It was I was reinstated.
No, reinstated, all right.
Directed,
but
order was set aside.
You were not working.
That period I was hospitalized.
But how can that be considered as service period?
No, not. And well, for the purpose of other benefit, I'm not claiming for salary and all these things.
Not salary, even for regularization.
My lord.
The period one should be effective service.
My lord, unless that I was out of employment because of an termination order. That termination order is set aside. Right?
How long you were absent?
453 days.
14 months.
Yes, 453 days. That was the absent period they are saying.
Yes, 453 about
what the days? Yes. I have calculated, madam.
453 days you were absent.
Absent. That because of the medical ground.
That's all right.
I was terminated for that reason only.
You were terminated on which date?
31/10/2023. 30/10/2023.
30/10/2023.
Unaccepted.
And reinstated on?
Reinstated on 4/3/25, my lord. Just after the judgment of this Hon'Ble Court. It was 9/3/23. 25.
9/3/25. But 453 days you are not entitled to.
Well, kindly see my lord's order. What the court has said.
Yeah.
Page 34 may kindly see. What the 32? Page 32. That is not the concluding paragraph. Therefore, shall I read, madam? Para 6.4. Therefore,
34.
Yes.
My lord, so page 33. 6.4.
Therefore, this court is inclined to quash office order.
Therefore, this court inclined to quash the order of while passing the set of this court directly pass to re-engage the person in service within a period of 2 months with some rate of receipt order. The break period of service be regularized in accordance with
break period of service be regularized in accordance with law.
That is the order.
In accordance with law means 453 days has to be minus. Remaining period you have to give.
Yeah, if that will, I have also pleaded that, my lord. Kindly see my pleading also. Then I have said, if they will deduct that, I will be regularized on 29/6/25.
For all practical
purposes, if that will be deducted,
minus 450.
450 days. That kindly see my pleading, my lord. That paragraph.
Let's say here, the final order will file counter in this case then.
Para 14, I have short dated. This is the short one.
My lords, your lordship.
All right, you file a counter.
Well,
Mr. Bethra is requested to accept notice for OPs. First stop. Since a very short point is involved, come on, call this matter in the 3rd week of November 2020. Okay.
Well, I will take note of para 14 and pass also order. It will suffice the purpose. I do admit that. That will be my concession also.
My lords, I don't have instructions. That is the problem.
Let us get it now. Okay.
Item 33. 33, regularization of class 4 employees in the identical matter your lordship has issued notice and also granted interim protection. That is your lordship. I have also sought the copy.
Yeah.
Item 34.
Yes. The petitioner challenges the order of transfer, my lord, which has been passed in complete violation of, my lord, government policy, my lord. They have deployed me. Your lordship may kindly come to page 17.
To which place you are transferred?
But I have been deployed from Dalia, Bangoradia Primary School to, my lord.
How many kilometers?
Well, distance will be 10 to 15 kilometers. Here, the government's guideline says that it's a statute.
7 kilometers. 11 kilometers.
But it's a statutory guideline of the government that since I was continuing on deployment in the present school, so I could not have been transferred or deployed further as per the government policy, my lord. This policy
are immune from transfer.
My lord, my deployment could have been cancelled, so I could have been reverted back to my original place of posting, my lord. And this guideline has been framed as per the provisions of RT Act, madam, Right of Children to Free and Compulsory Education Act. You also may kindly come to see that I have also.
No, where is the grievance? Assuming that some guideline is violated, where is the cognizable grievance?
No, my lord. Another point, my lord. Since I have been appointed as a block booth level officer, my lord, for verification of electoral rolls, my lord, as per the instruction of the state election commission.
You argued that matter, no? Who argued that matter?
Then that's a different context, my lord.
No, even otherwise. Apex Court said, violation of law per se is not a ground for granting relief to the litigants. There should be grievance.
My lord, my grievance is that, my lord, since I have been appointed as a booth level officer for conducting verification of electoral rolls, my lords. So if I am transferred from that place, my lord, wherein the booth is, wherein I have been.
That's the worry of the election officer.
No, election, and they have time and again instructed the DOs not to transfer such type of. Your lordship may kindly come to page 33.
Correct. If they have done, you let them challenge, not you.
No, they have.
You are only their servant.
Well, that's why.
If they say, if they are agreed, they will come before the court.
I will be failing in discharging my duty as a booth level officer.
What will be failing?
Because that as per election matter dependence on People's Act, if somebody fails to discharge any of the responsibilities cast upon.
On the following ground.
You are also kindly.
No employee is entitled to.
You are also kindly come to page 40. My representation has been forwarded to you. Also kindly the election officer, district election officer has. You also kindly have a glance to page 40, my lord.
But I will not interfere.
Just have a glance, my lords. Page 40. 40, my lord.
15/9/2020.
My lords.
This is by additional DEO.
Additional district.
To the block education.
My lords. Additional district electoral officer has forwarded my representation to block education officer. You also may kindly see the contest.
No, how you are aggrieved by this, I do not understand. School is just at a distance of 7 kilometers.
My lord, that's
go and work, whatever happens.
And my lord, they have this guideline has been framed, my lord. You
have said that, na? Under the RT Act.
RT Act, my lord.
Therefore, it is full force.
RT Act.
Yes,
so,
I read that.
as per the guideline, they could not have deployed me since I am continuing on my deployment. They could have cancelled my. I have no objection if my deployment is cancelled, my lord, and I am sent back to my.
Your grievance. You are at a distance of 7 kilometers. Instead of teaching here, you will be teaching there. Then those students will be benefited. We should move. Movement is the.
I may approach the authorities, my lords. I may approach the authorities, my lord. There is a provision for grievance.
You withdraw this petition.
The lordship may kindly.
Instead of my writing a judgment against you, you withdraw the petition with liberty to approach. Otherwise, I am dismissing this.
Under clause 5, there is a provision for appeal.
Whatever you want to do. But if you want to withdraw, well. Otherwise, I will write. That order may come in the way of your approaching the authority. He will say, High Court.
That's a lordship that observe. I will do liberty to approach the director.
Petitioner's grievance is against the transfer order. First time. Having urged several points for consideration, counsel for the petitioner seeks leave to withdraw the petition with liberty to work out his remedy at the department level.
As per clause 5 of the guideline.
As provided under the guidelines.
Matters.
Item learned ASC does not have objection for granting the leave. First up, in the above circumstances, petition is disposed of as having been withdrawn with liberty as mentioned above.
Item 35.
We are for promotion to lower secondary education service teachers to junior subordinate education service matter. Representation is pending before the authority, my lord. Annexer 10, madam.
It's in Oriya.
Oriya.
Address to the opinion of 2, madam.
2, madam.
For promotion,
my lord. Though juniors, 12 numbers of juniors are there.
The grievance of the petitioner is as to non-consideration of his candidature for promotion from the post of lower secondary education service to the post of junior subordinate education service with effect from 26/8/2025. First off, counsel for the petitioner submits that all juniors of his clients have been promoted.
12 numbers. 12 numbers.
12 juniors of his client have been promoted, and the candidature of his client has not been considered for promotion. And therefore, this court should intervene in the matter. First off, he also draws attention of the court to the representation dated
8/9/2025.
8/9/2025, a copy whereof avails at Annexure 10 in that regard. First. Next paragraph. The agency on request appearing for the OPs opposes the petition, contending that there is no right to promotion recognized in service jurisprudence. That although right to have the candidature considered for promotion may avail subject to restrictions. First up, having so contended, he agrees to instruct the OP number 2 to consider the subject representation if all contentions are kept open. First up, he also requests to prescribe a reasonable period for accomplishing the task. First, next one, in the above circumstances, this code of 8 weeks kept open to solicitude. Next.
Time may be
8 weeks.
Yes, ma'am.
8 weeks.
Item 36.
May I please, Your Lordship? My Lord, although in this case also order of transfer is under challenge, my Lord, here my rights are affected, Your Lordship.
How many kilometers?
My Lord, it's an inter-district transfer. I could not have been transferred from one.
No, I am asking you, how many kilometers?
It will be around 100 kilometers, my Lord, from Puri district to Jagsonpur district, that is Paradip, my Lord.
How long you have been in the same place?
Your Lordship, I am affected. I am losing my seniority by this
I am
sort of.
asking a question to you.
I am since 2012 there, my Lord.
2012. 13 years you have been
My
there.
Lord. Your Lordship, may kindly see this order of transfer. They have said that I will be junior most in the new district, my Lord. Your Lordship, may kindly see page 14.
That seniority is state-wise or
district-wise?
Right?
It's a district cadre post, my Lord. Hindi teachers are district cadre post. As per their own guidelines, district cadre employees cannot be transferred. They can only be transferred on their own representation, on mutual ground or on health ground. I have not made any such representation, and on administrative ground, one employee, district cadre employee, could not have been transferred to another district. My Lord, you will also kindly see page 14.
Page 14.
This order of transfer.
Where is that norm which says only intra-district transfer?
Your Lordship, I am coming to that resolution.
I have agreed with this. Now, up to that point only. What are these service matters? 1 minute matter.
My Lord. Your Lordship, may kindly come to page 15. That is the resolution of the government dated 14/5/2025.
Annexure 4.
Annexure 4, my Lords. Your Lordship, may kindly come to next page, page 16, clause 3.
Clause 3.
My Lords. 3, capital A. Inter-district transfer, my Lord. Grounds of transfer of employees transferable under different grounds. The employees of different category may be transferred from one district to another on the grounds mentioned against each in the following table.
Only mutual cases and cases of terminal disease, etc. alone can be.
Can be. So I have not, they have to, for that, they have to make an application. So I have
emergent notice.
Lordship, I have a glance to the input order, my Lord, page 14, last, my Lord. The transfer has been made on their own request.
But he is saying I have never made any request.
I have on affidavit I have stated that, my Lord.
My Lord, that is there.
But without seeing so many matters we have seen, your authorities just mindlessly, they will print everything and wherever they want to send these people, they will send. No normative, no promotion is given. Juniors have been given, he has not been given. But anyway, they are making representation. Only High Court is governed by representation jurisprudence. Therefore, I am also become now accustomed to that. The new jurisprudence how your High Court has invented, which is unknown to very other High Courts in the country. Consider representation, consider representation. Yes. Issue emergent notice. First, learned ASC on request of the court accepts notice for the OPs. Emergent notice to go for 25 months. First up, an application supported by affidavit is moved, seeking stay of the transfer order. First up, counsel for the petitioner submits that intra-district transfer is permissible, but the extra-district is impermissible. Inter-district is impermissible in terms of the government notification dated 13468, number 13468 dated 14/5/2025, Annexure 4. First up. He also points out that his client has not made any request for mutual transfer or otherwise. Next, in the above circumstances, the case is made out for granting interim protection in terms of the prayer in the application. First off, application is allowed and the impugned transfer order, to the extent it relates to the petitioner, is hereby stayed. First off, call this matter in the 3rd week of November. Stay till next date of hearing. Call this matter in the 3rd week of November.
But I may be continue at that school, SSB Nodal High School.
Have you been relieved now?
No, they say that
Date, transfer order is dated?
That is 26/9/2025.
26/9.
This is the recent order, my lord.
Petitioner to be continued in the place where he was working before the issuance of impugned order.
Obliged, my lord. Obliged.
I'll revert within 2-3 minutes. It's thus. Yes.
So this case, my lord, the petitioner is a professor. Since he was initially in the IGNOU, and now he has been appointed in the Ravensa University. This is item 37. Item 37. Ravensa University, guided by the Odisha University's first statute 1990, which provides if a person coming from a central university, IGNOU is a central university, then I am to get this pay protection, and as well as the past service is to be counted as per statute 260. And when that was not considered, I came before this Hon'Ble Court. I filed a representation, and that case was disposed of by granting me liberty to file the representation. And now my representation was disposed of, and order was passed in my favor on 26/8/25 in adherence page 59, annexure 14.
59.
Minor.
Protected.
Yes. Protected and past service
320 and the past service also.
Also, man. That is the statute, man. Okay. So now, when this order is on 26/8/25, man, pursuant to my lord's order. So now, in page 16, sorry, annexure 16, page 61, on 3/10/25, after about a month, now that order has been withdrawn. Without reason, nothing. Well, you see, the professor is now hereby withdrawn. Only one line, nothing more.
The registrar of the university has passed this.
Yes. Yes, he himself is the authority, passed the order.
The earlier order is also his own.
Yes, he is the signature.
No notice was issued.
Nothing, well.
Where have you stated in your ground?
Yes. No notice. That is only ground. No notice, no information. Kindly see, my lord. Paragraph 15, 16, all these things I have stated that.
No notice, no
notice, nothing.
Issue. Yeah, you have sought for stay of the order.
Yes, ma'am.
Issue emergent notice. AGA appears for ASC appears for 1.
Other I have to take
emergent notice to 2 and 3. Next one. The Debt Counsel, Mr. Das, draws attention of the court to the application in IA number so and so, supported by affidavit or interim protection for the impugned order. First off, he argues that in terms of first statutes of the university, his earlier service and the pay protection ought to be safeguarded. And accordingly, they were, while the office order dated 26/8/2025. First off, he further draws attention of the court to the impugned one-line order dated 3/10/2025 at annexure 16, which has no reason nor rhyme stated, in which no reason or rhyme is stated. First off, he also tells that such an adverse order could not have been made without opportunity of hearing, principles of natural justice being sacrosanct. In prima facie case is made out for interim protection. Next paragraph. In the above circumstances, application is allowed. The impugned order is stayed with a direction to extend the benefit of order dated 26/8/2025 as before during the pendency of the petition. During the pendency and subject to outcome of the petition.
Item 38.
May limit grievance before lordship is that for disposal of representation under Annexure 6 as page 27, which is pending before the sub-collector Deccanar since 24/9/2025.
What is that?
Actually, there is dispute between two puja committees. In Deccanar, Gajalakshmi Puja is celebrated. There is adjoining two puja committees. There is dispute. So therefore, it was amicably settled amongst the parties by intervention of collector and sub-collector. Because after that also, one puja committee is by violating that terms is doing puja and with certain irregularities by encroaching upon the national highway. We have objected to that because he is not complying with that. That is why I filed representation. That representation is pending before the sub-collector. He may take a decision on the same by giving up. That was all.
Instead of doing puja, they are doing dispute.
Annexure 6 is the representation. 6. Yes, 27.
14/10/25.
14/9/2025.
14/9.
My lord.
14/10.
In top, my lord, page 27, 14/9.
14/9.
Wrong. Last time, you kindly come to page number 59.
Wrongly typed.
Okay. I thought that he has moved well in advance in that time. The short grievance of the petitioner is as to not consideration of the representation dated 14/9/2025. A copy whereof avails at Annexure 6. First of all. A grievance is made out in the said representation as to some internal dispute amongst the pujaris,
puja committee
members. Despite resolution of the earlier dispute at the hands of district collector. First off, council submits that he is going to be satisfied if a direction is issued to consider the subject representation in accordance with law. First off. Next paragraph. Learned ASC agrees with consideration.
Let them file a fresh representation because it is addressed to the President Marito Bazar Puja Committee.
President, I will submit before the
Learned Council for the Learned ASC appearing for the official peace submits that. There is no proof as to the subject representation having been submitted, and therefore, if a fresh representation is made, he would instruct the district collector to look into the same, keeping in view the parameters of law. With this proposal, counsel for the petitioner is agreeable. Next paragraph. In the above circumstances, petition is disposed of, reserving liberty to the petitioners to give a fresh representation coupled with evidentiary material in support of their complaint within 2 weeks. And if one is made, the district collector shall take a call on the same within an outer limit of 4 weeks. Giving opportunity of hearing to all the stakeholders. Physical hearing.
In presence of both parties.
Personal hearing. Both the opportunity of hearing, personal hearing to all the parties. Okay.
Item 39.
Yes.
My lord, I will seek for a passover after lunch.
Passover? I will assist you. Start now.
And I'm not
What is
accused-
this matter about?
This matter relates to, this is a co-warranto case, my lord. The petitioner has challenged the illegal appointment of the vice chancellor of the OUT University, my lord.
He has no, OP has no requisite qualification.
My lord.
What qualification he should have had? All right. If you tell me the famous book case on Go Warranto,
my lord,
I will praise you in the order and I will issue notice also.
My lord, one is Rajesh Avasti versus Nandlal Jaiswal. My lord, the other one is Kashinath G. Jalmi and others versus the speaker and others.
But about the university itself, there is a famous case. You go to Darcy and ask him. Go and ask. Darcy is sitting there. Ask him, which is that judgment? You do not? Darcy is sitting. Famous judgment is no, within the university, famous judgment begins. Mysore University versus G.K. Govinda Rao.
Yes, G.K. Govinda Rao.
That's the first judge.
Yes, that has been referred to also there.
But he performed well. Heard learned counsel Sri. What's your name?
Shreyans Rajguru.
So.
My lord's last order, your lordship kindly see. Actually, yes, no locus standi to challenge.
Let notice go. Because he argued so well, youngster. Yes. Vacation is also coming now. Is it not? Yes. Heard learned counsel Sri so. First off. He submits that the OP number, which OP number 5 does not have requisite qualification to hold the post in question. And therefore, this is a fit case for issuance of writ of go warrant. First off, he also cites decisions of the apex court in the state of Mysore, University of Mysore versus G.K. Govinda Rao or Govinda Rao versus Mysore, I do not know. And Nandlal Jaiswal.
My lord. Rajesh Avasti versus
Rajesh Avasti versus Nandlal in support of these things. First. Next one. He has made out a case for issuance of emergent notice. First off. Next paragraph. Issue emergent notice to the OPs. Returnable within 8 weeks. Okay. We should always use the opportunity. Opportunity does not come to anyone very often like bonus. Okay? Whenever you get opportunity, make best use of that. One small incident I will tell you. Our Attorney General K.K. Venugopal, his father was K.K. Nambiar, M.K. Nambiar. He had to go to England to do some job, maybe cooking or something like that, I don't know, because one of his relatives was in England. He went to England and studied there. What's the point? He did not go there for study, but he studied. And he became such a great lawyer, perhaps a very great lawyer, M.K. Nambiar. Just look into many books you will see about him. That is, whenever you get opportunity, make use of that. The great minus point of person is closing eyes when opportunity knocks at your door. Missing opportunity is brilliant. All right?
Item 40.
Yes.
Last yesterday, your lordship, that decision election officer versus state of Karnataka. I could not get it, my lord.
Why you could not get it? Is there? Justice Kumar's judgment.
Justice Kumar, your lordship has referred him, but I could not get that.
I have argued that.
I have also asked the court master, my lord.
I'll give it to you. Can anybody get the district election officer versus state of Karnataka? Take up that. It's a reported judgment.
My lord, but that was not, I could not get it right.
You say like, then what should I do? There, they have differentiated between transfer in service jurisprudence and deputation in election law, not service law, in election law, where an employee of the state government is drawn for election duty. That is not a case of transfer. They have said that way.
But my case is, my lord, I have transferred from my serviceman. Though I have reputed as polling BLO man, booth level officer. That is my case, man. I am under the Tahsildar come AERO, Gania my lord, that election officer. I am engaged as for the purpose of my lord special intensive revision for the BLO under the my lord Chief Electoral Officer Bhubaneswar, my lord.
Correct. But who pays the salary to you?
My lord, the DEO, my lord, District Education Officer.
Then who pays the DEO?
My lord, he has violated the order of the Chief Electoral Officer. Chief Electoral Officer has directed that.
Correct. Why you worry about that? If Chief Electoral Officer comes here, we will consider it case. And you are only the servant of the government.
My lord,
wherever government says you should go.
My lord, another thing, my lord, in the mid of the sessions, my lord, in the mid of the sessions, my lord, the academic section start March and April, and I will transfer in October, my lord. That is my difficulty.
How long? What is the distance between the
distance? 40 kilometers.
40. But you have conveyance facility.
No, there is no conveyance.
No bus at all. No. Only people go by helicopter.
Man.
What that is within the block, my lord, not so distant, my lord. The Lordship kindly glance, my lord, in page 14, my lord, the last para, my lord,
for 0.
Here, my lord. He shall not be relieved until the process of revision of roles are concluded, my lord.
That is my case, my lord.
That is there.
Though he has reflected but transformed and relieved me.
He has also, my lord, submitted a representation annexure page 17, my lord. 117.
You consider the representation?
Yes.
But till then, continue him in the same place.
Subject to he has not been relieved.
Otherwise, he will not consider it.
Well, order itself, he will not relieve, my lord.
Day before yesterday, he has
relieved. I will direct consideration of the representation, keeping in view that district election officer's note also.
Yes,
all right. But till then, you continue him in the same place. Now, why in the mid of the academic year are transferring? How can he have? You better do one thing. Are you married? Your client is married.
Yes,
ask him to get married to another lady. Take down. Challenges to the transfer order. First off, counsel for the petitioner submits 2 grounds in support of his contention. Which, 1, no transfer could have been done during the mid of the academic year. 2, the transfer is bad because it violates the instruction of the district electoral officer. Election officer it is. District. Take out the 1950 Representation of People Act. Representation of People Act 1950. You have that. What is he called? District election officer or district electoral officer?
No, here is electoral officer. Office submitted to.
And the district election officer.
District election officer it is. Section 4(3).
Chief electoral officer.
No, that is chief electoral
officer, madam.
That is a state level officer, given officer.
District
election officer. Yes.
Place to election.
Second is what? Learned counsel for the petitioner also draws attention of the court to the representation made by his client at Annexure. Sit down and answer. This is not a primary school.
4 series. Onwards. 16 and 17.
Annexures?
4 series, page 16.
Annexures at 4 series. At Annexure 4 series. First off, he tells the court that unless judicial intervention is made, the said representation should be kept in cold storage. First, next paragraph. Learned ASC on request appearing for the OPs, official OPs, opposes the petition contending that transfer is an incident of service and therefore every government servant should go and report for duty wherever he or she is transferred. First off, having so contended, now very fairly he submits that he would instruct the block education officer to consider petitioner's subject representations, keeping in view the decision of the apex court in Varadhara versus State of Karnataka. They are going to find. First off, this is appreciable. Next, when the above circumstances, petition is disposed of. Directing OP number, block education officer, OP number.
That is DEO, my lord.
DEO.
3, my lord.
3.
District education officer.
District education officer. To take a call on the subject representation as early as possible. Until the call is taken and result thereof is communicated, petitioner shall be continued in the same school in which he was working before the issuance of the impugned order. All contentions kept open, no cause. Next.
Item 41.
May I please, Malad? Malad, this is an old matter, Malad. In this matter, Malad, the present petitioner apartment is in the outskirts of Bhubaneswar, Malad. That is in between Bhubaneswar and Cuttack, Malad. And there was no such network, Malad, mobile network. And for which, Malad, the present petitioner previously, there was a direction from this Hon'Ble Court, Malad, that is Annexure 1. And subsequently, there is a contempt also, Malad, that is Annexure 2, Malad. And later on, the Chief General Manager of BSNL has rejected the representation of the present petitioner.
What is your grievance?
My grievance is that, my lord, there is no network in that locality. Yes, man. BSNL network is not there, my lord. So it is. So the inhabitants of that locality, my lord, they are facing lot of problems, my lord.
Where is the duty to furnish network?
My lord, it is the duty of the BSNL, my lord. That is the.
Show that.
Well, kindly have a glance at the rejection order, Mal. Can I read out the last para, Mal? Annexure 3, Mal. This is the last para. At present, no new mobile BTS equipment is available with BSNL Odisha circle. Moreover, the above location is not commercially feasible for installation of new BTS equipment, as the cost will be as high as around 80 lakhs in addition to monthly rent for the site, electricity, fuel cost for generator and security cost. As such, there will be no return on the investment. It will be very difficult to recover the above capital and running cost considering the mere revenue that is likely to be generated from the BTS, Malad. Malad, we are in a welfare state, Malad, and this BSNL, it's a nationalized, Malad, I mean a company, Malad. Yes, Malad, it's their duty to...
There should be some full stop between two sentences,
Malad,
so that I can assess,
Malad,
the jurisprudential quality of your submission.
Malad.
Where is the duty to provide network?
Malad, because we are the consumer, Malad, and
You may be consumer of so many things.
Malad.
Where is the duty to cater to the consumption?
Malad, BTS, BTS is there, but it is 3 kilometers away from the present locality, Malad.
They are saying, we are not interested in doing.
Yes.
Where is the public duty?
Malad, because it's a public limited company, Malad.
But there are many public limited companies.
Yes, Malad.
They do read 86 Supreme Court, LIC of India versus Escorts Limited, where they said the business interest will dictate the policies of the government companies. Chinnappareddy's judgment, one of the finest judgments I have ever read.
And whatever he has mentioned, Malad, that is not true, Malad. Because the new
will say,
Malad,
on Amavasya, there will be lot of moonlight. Therefore, we have decided not to go for installing any tower. It may be wrong, but where is the duty? There will be no sunlight, moonlight in Amavasya, or in your state there is.
No, my lord.
No, it will not be there, no?
Yes.
Yes. Suppose it says on Amavasya, there will be lot of moonlight, which is not good for our towers, and therefore we do not establish that tower. Do you mean to say we can examine whether in Amavasya moonlight will fall or not? No. It is his assumption. Unless there is a public duty, therefore, any standard book on law of writs, like the judge here, that B.L. Hansariya, that writ jurisdiction, is a wonderful book. His son has updated it. And just Hansariya was from your court only.
Yes,
He writes, unless a public duty, that may be by contract also, by law, or by policy, executive decision. Unless there is a public duty, you have no right.
Element of public duty.
Correct. Element of public duty. Unless you show that, how can we interfere? You are facing a lot of problem because without mobile we cannot live only.
But this,
I feel uncomfortable if I do not see the mobile now. That is the position.
yes, ma'am.
But where is the duty to provide mobile tower? This is a case of damnum sine injuria. There is difficulty to you, damage to you, but there is no legal violation of legal right. So if you permit, we will put your case from tower to tower now.
No, my lord, because recently that locality is, my lord, this new Bhubaneswar city is going to be start over the year.
In fact, my lords, this is for withdrawal of the writ petition.
No,
My lords, can you see?
No, we have given it, my lord, because
Both the matters.
memo was given, my lord. It was because of the out of that the petitioner was disgusted and so it is filed to withdraw, my lord.
You want to being disgusted?
He has already discussed, my lord. Since
He is rightly disgusted. The law is totally
from 21 to 2025, my lord. The matter has not been listed, my lord.
Petitioner seeks establishment of mobile network at a particular place, which the BSNL does not find it feasible. By letter dated 8/8/20, 8/8/24.
Yes, ma'am. 8 January 2021, ma'am.
8/8/2021. A copy whereof avails at annexure. Right. So, nothing is properly written. When a question is put to the petitioner, counsel for the petitioner, what duty the BSNL has to provide the network, he is not in a position to lay his hands on any law or ruling. First off. However, he submits that BSNL is a central government undertaking and that the reason assigned by them in the subject letter are not germane to the decision, and therefore this court should come to the aid of his clients. Next paragraph. It has been a long settled position of law of writs that no right, no right. First off. No decision of the court, no decision of any court, nor any decision of the central government which grants a right to have the tower established is demonstrated before the court. First of all, in the above circumstance, petition being thoroughly devoid of merits is liable to be, and accordingly is rejected. Next.
Item 42.
I put it to maybe withdraw, my lord. That matter is infructuous ones. That is already infructuous.
42.
That is also a old matter.
This code of as I will become infructuous on the submission of counsel for the petitioner. Okay.
My lord, I am appearing for OP number 3. Item
This
number.
was handled before my lords. Your lordship, this was disposed of.
Yes, sir.
Italy, okay. Disposed of by the order of the Honorable Coordinate Bench, and that was challenged before in the appellate court. The appellate court, my lord, that was the order of the Honorable Single Judge.
Set aside the order of the single.
And directed that the matter to be reheard, and because the matter was not heard at the time of disposal. Accordingly, my lord, it has come for
hearing,
admission. And number two, my lords have filed an application for implication of parties. Those are going to be affected in the matter I am going to succeed.
Will issue notice on that application?
My lord, unless they are made parties.
No, we can't make them party without hearing them.
All right, my lord.
Issue
one small prayer, your lordship,
on subject application.
I'd flag D. I filed application for intervention, your
A
lordship.
copy has not been served on me. Let them serve the copy on me.
You copy.
Item 45.
Sir, do you want my judgments back?
I have given it for my lord's record.
Okay, keep them
From my lord, that particular item, my name was there. It has been transferred. My learned senior name may be reflected, my name may be deleted.
His name will be deleted. My name along with our name was there. His name should be deleted.
Yes. He is your disciple.
Yes, sir.
But I want to be your disciple. I also want to be. Yes.
In this case, my prayer for
modify the order.
No, what happened, my lord? My services was done. Just I'm 2 lines. I'm placing the case there.
I understood. That 8/12/2007. Instead of that, it should be 18/6/92.
Original date. My services were terminated. I won the case. No, notice has gone. This is a disposal. I have given a short, convenient dates of events. My state only.
Where my lord state is?
Ready. Only limited, my lord. Very small prayer also. Yeah. Because this is a good number of cases has been fought by different person against this person. That is why
series of.
That is why I'm just placing it without opening the brief also. But I was appointed in 92. I was terminated, and in 96 I assailed the order of termination. It was set aside by the appellate authority. At the relevant time, it was an honorary restitution. But I won the case on 1/11/2007. Kindly,
1/11/2007.
That order was passed by the appellate authority. I have given all the dates, my lord. May not write all this. Just I am placing.
Yes.
I won the appeal. That appellate order was challenged by a person, not the management. That there was also no stay. The writ petition was dismissed. The person who was appointed against my termination vacancy, he also attempted to challenge that order, become unsuccessful. In the meantime, because of the dismissal of all these cases, his services was also terminated by the management, but he was in connivance with that management. See, he filed an appeal to the State Education Tribunal. By the time the institution was aided, tribunal also didn't grant any interim order against my reinstatement order. He carried the appeal to this Hon'Ble Court in FAO. FAO was also not entertained. It was finally dismissed. Against that order, he went to the Hon'Ble Supreme Court. That was also remanded back again, and it was also finally dismissed. Suppressing all these things, he was contesting all these cases. Again, my reinstatement order of 2007, again he attempted to challenge it in a separate writ petition. That was also dismissed. Carried to the writ appeal. That was also dismissed. All these way, my lord, though my reinstatement order has never been stayed by any of the Hon'Ble Forum, though it has been challenged in different stages, I could not be allowed to join. I only could be allowed, all these, after the disposal of all these cases, I could have only joined in this particular date. That is the date on which in 2017. And that is why my service was approved. And I was paid only the salary from that particular date. So my reinstatement order, at least from the date of reinstatement, if I will be get, in the meantime, I have retired from service.
But you are not working during that period.
No, only because of this. Because I have had my termination would have been continued all the way. And I have been reinstated, joined in the previous case. I was doing that 4 cases before. There, my lord have said that for 450 days you will not get benefit. I understood, my lord. What happened? the authorities knowing that I have succeeded in my appeal, so I am the stakeholder against that particular post. The person who was continuing against that post, his service has also been terminated by the management. He attempted this futile exercise by challenging the order, not get any interim order also, and all the cases were dismissed. That person was favored with the salary. My responsible submission is authorities should have. So if the matter is sub judice, they should not have paid him the salary. Now what the ground they have rejected my claim is because you have paid the salary to the other person, you are not entitled. That is the
he worked and got the salary.
No, he was not. He was terminated in 6/12. I was reinstated on 1/11/2007. He was terminated on 6/12/2007. That order he challenged the tribunal. He didn't succeed. But beyond that 6/12/2007, they have paid them the salary. These are the facts on record. How could they? My question to the authorities: how could they pay them the salary when he has been terminated by the management itself? Whether I will get or not, that is a separate issue. My lord will decide it. But can they give it to the person who has also been terminated? He has not succeeded ultimately. But now denying my salary because he has got the salary. He got the salary only because of the officers helped him out to get the salary illegally. Now I have been aware of everything, my lord. So at this juncture, if my lord permit, I will place the date chart I have given, a small date chart I have prepared and I have given on record also, the convenient note. Only all these dates, because these are the dates only to be taken note of.
That Basant Kumar Panda continued even after termination.
Yes. And got the salary also from the government.
Yes,
I did that also. I will give you another one.
Mohanty, what he says is,
Yes.
he got the reinstatement order, which was subject matter of challenge at various forums, where there was no interim order. Subsequently, all those challenges failed. And that Mr. Panda continued to the salary
Up to 2014.
Yes. But how this person, what he says is, I did not remain away from the service. I had an order in my favor. I was kept away from the service. Therefore, why should I be punished?
This is an infighting between the two headmasters.
Correct.
Two persons.
Correct. If there is an order to reinstate him.
Yes, but since 97 to 2017, so far the salary component is concerned 97 to 2014. All the way as there he was in work.
No, he was terminated.
Since 97 onwards, as he was the headmaster, because since terminated since 96. So far the present petitioner is concerned.
Correct.
So that day onwards, as he was there.
But he was also terminated.
Terminated.
In which 2007. I have given the death chart. It is there on record. I have given to one to him. See the death chart. 2007. See, I was reinstated on 1/11/2007. He was terminated 6/12/2007. Immediately thereafter. And challenging that order, he has gone to the tribunal in the appeal number 35 of 2007.
Pendency of the cases in different forums.
Dismissed. But after dismissal, there was no interim order also.
No, but process is going in a minor.
There is a candidate who is ordered to be reinstated.
But since
there is a candidate who has been terminated. You want to continue?
Since 1997 to 2007.
No, that was 6/12/2007 onward.
Since 21/1/1997.
All right, 1/11/2007, he got an order. And the other party was sent out on 6/12/2007. Even then he has been paid salary. There was no interim order.
No, interim order was not there.
And finally he failed also.
But they have approached the Hon'Ble Apex Court, then it has been remanded back, then it is in the session, then subsequently after the dismissal, they once again gone to the Apex Court.
No, where was the interim order to continue him?
No, interim order was not there.
Then why did you make the payment?
As was continuing, my lord.
How is that continuing? Here is a person who has obtained an order from the court, tribunal, that he should be reinstated. Him you do not reinstate. One who is liable to be shunted out, he has been continued and you have paid the salary to him. Why he should be punished? You recover that money from the officers who paid and pay that money to him.
In the meantime, they have retired.
No, they have retired means you go and dig the grave.
Well, can I have a glance to A by 4 to the counter for a moment?
Where is the,
That is the order.
rule of law? Rule of law is a basic feature of the Constitution. That's what Apex Court said in Keswananda and in Indira Nehru Gandhi. Here is a person who is holding in his hands an order of the court, tribunal. There is a person who has suffered dismissal. And between these two, whom we should favor?
It is at A54 million. Page order. Elementary education. This is order dated 22/5/2024.
Annexer?
It is at annexer A by 4.
What it says?
To the counter Miller.
Distorted text they have stated. I have given the text statement.
This is by whom?
Director Elementary Education, Odisha.
To what effect it is?
Effect, my lord, is earlier occasion I came wherein direction was given to consider it, he rejected it. That is why I have challenged it.
This is the impugned.
That's all right. Now only leave all other things what happened. 1/11/2007, an order he secured at the hands of the tribunal.
No, that is by the appellate authority of the inspector of school. Now the DO. The same appellate of DO.
The appellate authority passed an order setting aside his termination. All right. Then why he was not put into reinstated into service? First question. Number 2. Why a person who was terminated from service was continued in service?
Well, since 97, they are permanent.
You leave that period. You leave that period. Till you are saying 97 again. I say, I will tell you to ignore that period. 2007. With effect from 6/12/2007. In your school, Allah's wonderful wonderland, is it prescribed as a lesson?
Yes.
In our time it was there.
Previously it was there.
Now it is.
Even Allah then would be surprised by all this. All this can happen only in Alice in Wonderland. Such things are happening. A person who was wrongly terminated, termination is set aside, and that is challenged by various other people. No success, no interim order. He is not given implement. He has not been given the benefit of the order. There is a person whose services have been terminated. Within 1 month of his getting the order in his favor, he has been continued in service, robbed, and he lost all his cases. He took away the money also. What should happen to him? To double injustice. Why it happened? Which officers did this? You deduct amount from their pension.
For that, exactly, that interregnum period for which it has been paid, and so far the no stay is there for that particular period, and he has not been allowed to work. Well, let me take the specific instruction for that particular period.
Yes.
By that I can clarify the entire situation.
All right. When will you do that?
10 days.
On 29th?
Yes.
Call on 29th.
Yes. 29.
20.
Item 46.
Yes, item 46 minutes. Before the vacation, I received the counter minutes. I only pray 1 week time to file each on days.
30th.
Great figure.
Get the request now.
There are two matters, my lord. In second case, they have similar. Second case, no compromise will file. Let the state file counter. Second.
State, I will never direct the other side to file counter, but you can take maximum benefit. Absence of counter
exactly
will be to your benefit. I really do not understand why your members of your bar say they may be directed to file counter. All it you take absence of counter can be made best use of.
Only for the reason, my lord, at the time of hearing, they
will say we want time to file.
That is why only.
In the meanwhile, whoever wants to file the counter may file one.
So that
The first item, it has been.
Yes.
Okay.
Item 47.
Item 47, let's here the state has not filed counter, your lordship.
Take maximum benefit of that.
Because here the prayer of the petitioner has been rejected. Based on the liberty the petitioner filed, based on the liberty by the ordinate bench, the petitioner filed the writ application. In the meantime, they are rejected. And the
What is the order dated 24/11/24? This order.
That's
24.
Yes.
10/2024.
24/10/2024.
And 11/7/23.
But these are the orders.
So far the opposite partner 1 and 2. The opposite partner. That counter we have filed,
But not serve me a copy, your lordship.
Do you have copies?
Yes.
Give that.
Serving course.
Call on 30th.
Great figures.
Yes.
Item 48.
48 may have been valid. Even though the counsel for the opposite party number 5 has sent an appearance, but no counter affidavit has been filed on behalf of him. But the case is just that even after repeated actions, when the conduct of the opposite party number 5, who is an employee of the institution, my lord, a disciplinary proceeding was initiated and ultimately recommendation was made to disengage her services, because as per the rule, the resolution, even though we are the appointing authority, but we cannot directly disengage the employees without the recommendation of the collector, my lord. So
That's the recommendation.
we only
says that.
We only have to recommend it. The collector has to disengage. The rule is at, my lord, Annexer 15, page 44. The relevant portion is at page 54, my lord.
You have recommended for.
Yes, my lord. We recommended for disengagement under Annexer 16. Thereafter, a reminder was again sent under Annexer 17, my lord.
They are not taking any decision on that.
I am coming to that. Thereafter, when the collector did
I am for OP number 5, your lordships. I am for OP number 5.
Thereafter, when the collector did not take any steps, my lord, we issued the order of the disengagement under Annexer 18, my lord. That was challenged by opposite party number 5 before this honorable court, and this honorable court under Annexer 19, while setting aside the disengagement order, remitted the matter to the collector with the direction that you consider the case in accordance with law, my lord. That is at page 62, my lord. The relevant portion is at page 63, paragraph 5.
Brother Rautrai's judgment.
My lord.
Brother Judge Rautrai's judgment.
Yes, my lord. Paragraph 5, page 63. Thus, in view of the prescribed procedure as per...
Matter is remanded and with the direction to take the decision.
In accordance with law. What the collector did is, as this honorable court set aside the disengagement order, basing on that premise, he directed that you allow her to continue and pay her the salary. The direction was to act in accordance with the law. The rule says that after the recommendation, the collector has to issue so cause notice to the candidate as well as the institution. Thereafter, after hearing both of them, he will take a decision on the disengagement order. Instead of doing that, he straight away said that as the impugned order, disengagement order has been set aside, therefore you allow her to continue. The impugned order is at page 68, my lord, Annexer 23. The relevant portion is at page 70, my lord.
What was the allegation against the lady?
The lady was she developed a habit of remaining absent unauthorizedly, my lord.
How many times? How long?
For more than 5 years, are the regular intervals. Even after warnings were issued and notices were issued explaining that when her conduct did not improve, thereafter finally a disciplinary proceeding was initiated. The relevant portion is at page 70, my lord. The impugned order. Annexer 23.
Now, without approval.
Yes, madam.
Can you pass a disengagement order?
That we agree that the collector
have passed that.
We should not have done that. And the collector sat over the matter for more than long period. Therefore, having no option, and the institution, the running of the institution was also getting hampered because the institution serving the children with disabilities, my lord. So
Children with disabilities.
yes, my lord.
How many children are there?
More than 40.
40. Differently abled
Yes,
children.
ma'am. It's a school for deaf. The relevant portion is at the second paragraph. In view of the above discussion, it is established that the disengagement order has been passed by the General Secretary Patita Bhavan Seva Sangh Nimapada against the prisoner in violation of the government instructions in the matter. Since the order of disengagement has been quashed by the Hon'Ble High Court, the General Secretary Patita Bhavan Seva Sangh is asked to allow the prisoner to resume her duty forthwith as per the district office orders dated such and such, communicated to such and such, and to clear the salaries, etc. of the prisoner within the time
Yes,
frame.
Mr. Monty, how do you justify this order?
But can I have a glance to the impugned order?
Yes. No, I'm asking. His duty is either to approve or disapprove this. How could he direct reinstatement, pay so and so? What is his jurisdiction?
But so far the disengagement is concerned, prior to that, he has been given all possible opportunities to develop. Can I have a glance to page 69, that it is quoted.
69?
Exactly. That is the impugned order.
No, I am sorry, Your Lordship, to intervene.
Yes.
Your Lordship is speaking, order is in WPC number 29932 of 2024. It is not brought to the notice of this Honorable Court. Pursuant to direction of this Honorable Court, my lord, the collector has passed a speaking order, which is also impugned here in the WPC number 29932 of 2024. But thereafter, this is the consequential. Now, the consequential order is challenged by this by the petitioner here. The pursuant to the direction of this Honorable Court, whenever remand is made, my lord, that speaking order is challenged in the writ application number 29932 of 2024. Your Lordship may bring that writ application along with this, so that everything will be clear. And along with my writ application, in which my lord remand has been made, Your Lordship, that is 15386 of 2023. So that my lord, everything is cleared. Whatever that non-attendance for 5 years, it is a false statement. Everything is there in the writ application, that is 15386 of 2023. How, my lord, on monopoly, my lord, this secretary is working in that school? It will be proved. Your Lordship may tag this WPC number 15386 of 2023 and 29932 of 2024. So that, my lord, everything will be clear. Otherwise, my lord, these statement, my lord,
permit you and permit me to speak.
2992 is the present writ petition which I am placing.
29932, my lord, the speaking order is there, order dated 23 October 2024. Pursuant to the direction of this Honorable Court, my lord, in WPC number 2548 of 2024 or dated 8/10/2024, when remand is made, speaking order, hearing everything. Show cause is given to the petitioner. Petitioner has submitted the show cause, and both the parties were heard. And thereafter, my lord, the speaking order is passed. That is also impugned.
That is there, that today that matter is posted, na?
Yes,
no, that is not posted. It is the consequential order. Then after passing that speaking order, that the disengagement is bad in law, it is quashed. Thereafter, on representation, collector has said, though the disengagement was not given by the petitioner, then collector has passed that order.
Maybe my learned thing has not verified the cause list.
Kindly see the cause list.
This is the same petition, sir.
Mentioning 15386 of other writ application,
which was challenged, which I placed.
Yes. Another is, my lord, 25448 of 2024. Both are, my lord, may be tagged together.
Another
5448 of 2024.
Wherein I have placed Annexure 21, my lord.
If you come here, it will be convenient to everybody.
Yes, your lord. I am sorry, my lord, that I have certain problem, my lord, here at Bhubaneswar. Your lord, may call it, my lord, on Monday or Tuesday, Monday or Wednesday. Your lord, may call it.
28th? Okay. Request now. 28th already? 28th.
Along along with my lord WPC number 25448 of 2024, and my lord, your lordship will be pleased enough, my lord, to along with WPC number 15386 of 2023. 15386 of 2023 and 25448 of 2024. In this and second writ application, your lordship, it is connected to this.
Mention I have mentioned
whether that matter is pending or
that is pending.
All that matter also.
That 15,000 is disposed of. That 25,448 is pending.
My lord, the ground which has been taken for disengagement, that is there, my lord. Though a statement is made by non friend that 5 years, my lord, I am absent, that is not correct. That will be found out from that writ application.
All right. But one thing it will be convenient. 2 writ applications which has been made in the certificate, that may be called for.
In both the writ applications.
As the other side is making a mention. That, yes. This is in the certificate, my lord, in the writ application.
That I have mentioned in my certificate, place 2, my lord, of the writ application.
No, I'm not able to understand what. The other matter which is disposed of,
yes,
that file will be held.
Yes,
this is the version.
That
file.
That is mentioned in
that is in the reference.
That is also in the in the reference.
File is there.
No, file is not there. That reference is there.
File also.
The reference is there.
Reference is there.
Registry to put up the record of WP number
15386
along with this.
And 25448 of 2024.
That is,
yes.
It can be verified.
In the first matter, in the second writ application, and the writ application is 15388 of 2023.
Along with 25451 of 2024.
28
interim order to continue.
Interim order to continue.
On 28, you lordship placed it.
Yes.
Deeply.
But you want any other dates?
No. DP, as early or as possible, my lord, she has already retired. She is having no money, my lord, to manage herself or maintain herself. So therefore, as early date, my lord, I want.
Yeah.
My lord, deep look.
Sorry for the delay. Yeah.
My lord, item 45 which my lord has posted to 30th May. That matter wherein 7 to 2017. That
correct. That process matter.
So during this time, by skipping my lunch, I've tried that there is an interim order. So let this writ application and FO be called for. That's right. I have given the numbers.
Very good.
It will be transparent to
that's right.
Because some interim order is there by virtue of this order. They are continuing and subsequently it just stands vacated after disposal of this writ. That I found from this one document.
So what Mr. Das said is may not be correct.
Exactly. So for that, it will be
that will be recorded. Will tell what
easier to.
That means. Yes.
Item 44.
44.
Indian Navy retired
Item 44, my lord. Last occasion, my lord says pleased to pass order on 26/9/2025 regarding the defense retired person and applied for the lottery was there, my lord.
Yeah.
In the meantime, just before lunch, I have received this information, my lord. They are in the process, my lord. The language, the observation of this and all, the highest authority of the government for kind concession, they need some 1 month time, my lord.
1 month?
Yes, ma'am.
Why 1 month, brother?
1 month time for taking a decision in the matter.
Because land matters long back, so availability and the benchmark valuation, everything. The GA and PG department.
1 month finally. You will take the decision.
Yes.
But we will keep the matter pending.
No, let it be pending.
This court, while order dated 26/9/2025, had said as an
Prior to that, 15/9 also.
15/2025 had said that. Next one. The above order was followed by another one dated 26/9/2025. First. Which is as under. Next one. Learned DGA has voluntarily placed on record dated government's letter dated 10/10/2025 to the effect that a positive decision hopefully would be taken in the matter if a period of 1 month is granted. First up. Counsel for the petitioner, although initially opposed grant of any time, now fairly agrees with the proposal. Subject to the Riders Act, if nothing happens in the meanwhile, no further time be granted. First, the court agrees with this. Yes. In the above circumstance, call this matter for further hearing on 11/11. All right, on 10/11. Today is 10/10. 10/11 is 1.
11/11.
11/11. One more day you want. Very hard bargainer. Yes.
My lords, the letter will also 2 days.
For further hearing.
Matter may be treated as tied up matter, so that
Tied up. Further hearing means tied up. Any other
tied up matters means if
matter is treated as tied up, whatever. Put it. Got it. Why, suppose if there are many best judges in this court, far better than me, why it should be tied up matter?
I should not say.
My lord, apprehending if at the chilling of assignment, this may change, and this view will liberally come to. Item 49.
But it's a soldier's matter.
No, obviously.
This is not the way that
be respected at any.
Not only showing respect, you may show a lot of respect by stooping down wherever soldier comes without giving a plot. You need not show respect, at least near in the property. That will help him.
May I please, Your Lords? In this case, madam, I am for the petitioner, judge. And challenging the annexure 6.
Why are you so slow? Have you committed any crime?
No, madam.
Be open mind, be powerful.
Madam. This petition challenging annexure 6, madam. That is page number 56.
56?
Madam. Where the collector rejected the
legal error
certificate, madam. Before that, madam, when
because he says at para 4, neither party has a spouse living at the time of marriage.
Time of marriage, madam. My humble submission is that, madam. In the year 2021, the present petitioner was married with the deceased Gangadhar Nanda, madam. During the issuance of marriage certificate, that is on 25/3/2021, the wife, first wife of the deceased, and the deceased also died. First wife of the deceased died, my lord.
If the following conditions are fulfilled, namely either party has spouse living
At the time of marriage.
at the time of marriage, the first spouse was not there.
No, madam.
When she died.
He died on Gangadhar, the wife of the first wife of the deceased, died on 22 January 2021. Man.
22 January.
Man, 22 January 2021. That is page number 32. Also.
This is a certificate of death registration.
My lord, death registration.
So his observation that the spouse was living is not correct.
Not correct, madam.
No, my lord, the other private party has already their appearance.
Appeared in this opposite party.
However, my lord, on bare, though we have not filed the counter, on bare perusal of that 31, 1 second, my lord, I will invite my lord's kind 31, the certificate of marriage.
But certificate of marriage.
Which my learned friend is related.
Date of death is what?
My lord, date of death is, as has been mentioned, 22-1.
22-1-21. Date of marriage is?
Date of marriage is, my lord, it is at page 31.
Page 31.
31. The last part, my lord.
23rd day of February 2021.
21, this is signature. But before that, my lord, that paragraph, may I read, my lord? Appeared before me on 23rd February 21 that each of them, in my presence and the presence of 3 witnesses, who have signed hereunder and have declared that the ceremony of the marriage has been performed between them and they have been living together as husband and wife since the time and their marriage, and that is in accordance with the desire to have their marriage registered under this act. The shared marriage has this day on 23rd February 2021 been registered under the act having effect from 15th January 2019.
15th January 2019.
19.
Oh,
that is
the problem. My lord, in this case,
that's your problem.
My problem. My lord. During that period, my lord, she was not married to the deceased, my lord. And during the time of the first wife of the deceased was alive, my lord.
No.
And after the, sorry, no,
what kind of certificate is? Can he give a certificate with retrospective?
No. Even seeing that, I became astonished also. Whether it is a living relation or something else, no, I failed to understand.
It is admitted that during that period, the present petitioner was living at the house of the deceased man.
1 second. 1 sentence. His spouse died on 22-1-2020.
Sorry, wrongly I have submitted. That is on 17 February 2019.
17
February 2019. That is page number 35.
Assuming 17 February. How it will be with effect from 15 January? Which Monty has now pointed out. How can that be done?
My submission is that that is typical error.
You did not seek, you seek rectification. Then you come here.
No, my lord, I have mentioned in my read application.
You might have mentioned to your convenience.
My lord.
Where have you got it rectified? You have to move an application saying that it is not 15-1. It is 17-2 or 18-2, something like that. As long as this certificate remains.
But in this case, my humble submission is that during the first Tahsildar issued legal aid certificate,
yes.
Thereafter the opposite party number 4 filed challenges before this SDM Jaipur Koraput.
That is all right. Now question is when spouse is residing.
One submission.
Yeah.
During that period, during the issuance of Tahsil legal aid certificate and the challenging
pending the order of the Tahsildar, my lord. During that period, the opposite party number 5 has filed an civil suit before the Civil Judge Senior Division, Jaipur, my lord. During pendency of the during that case pendency, the SDM dismissed the case of the opposite party number 4, my lord. Thereafter, they preferred an appeal before the collector, my lord. But the collector did not consider the civil suit and cancelled the legal head certificate. That is the illegal.
Even otherwise, how can you hold such a certificate? You could not have applied for certificate because as on 22/1/2021, you were married.
My lord.
You had a spouse.
My lord.
How can that certificate say that the marriage would be with retrospective effect from 15/1/2019?
19.
It cannot be like that. You, if you want, you join a suit then. You make application.
Already I'm joined, my lord.
You are joined.
Joined there.
Await the judgment there.
My lord. But till that, my lord, due to the cancellation of legal aid certificate,
It should be cancelled.
Cancellation of the legal aid certificate, the petitioner did not get any pension and other benefits of the deceased, my lord. That's because, my lord, the opposite party number 4 is the 5 is the sister of the deceased, man. Married sister of the deceased. However, the present petition.
The person retired on which date?
My lord, read.
Sadashivananda.
Gangadhar Nanda.
This is Gangadhar Nanda.
Gangadhar.
Son of Sadashivananda.
My lord.
That Gangadhar Nanda passed away on which date?
He died on 12th 10th 2023. 12th 10th 2023.
2023.
My lord, 2023.
And your client married him when? It is only to get the pension, family pension.
Family pension and other benefits, my lord.
But the family pension is given to her so that during the lifetime of Gangadhara, he had cooked food for him and he worked there. Not for getting pension marriage. Marriage is a samskar.
My lord.
That is a sacrosanct, not for the
my lord.
You cannot say that you are married only to get.
Sorry, Your Lordship.
It cannot be like that.
My lord. Sorry, Your Lordship. That is another point, man.
No, that point is arising in the mind of the court now.
My lord.
This appears to be a stage managed thing. Stage managed marriage. So that she can take the money throughout for her life without cooking one single roti for that man. Pension, family pension is given with a laudable object that the husband was working in the army with the government and the lady was cooking food, looking after the husband. Therefore, after the death of husband, she should not starve. That is the object.
Yes, my lord.
Suppose if she has not made any contribution to the husband at all.
No, my lord. During the time, in the year 2021, they living together, my lord.
Living together is another thing.
Living
together is no point. Marriage is the point.
And
till we have not developed that to that level.
Since 2021 to 2023, they lived as wife and husband, man.
Makes no sense. Lived as husband and wife makes no living relationship is not for it.
No.
It is permissible, that's all.
After marriage,
that is not a spousal relationship.
After marriage, my lord.
After marriage.
My lord. In the year 2021, they both married before the special marriage of Sir Jaipur, my lord.
Where is special marriage act it is?
Page 31.
Show that.
Page 31, your lord.
Page 31.
Yes, sir.
That I am read out.
This is under the special marriage act.
Yes, your lord.
Which section?
This is section 16.
16?
Yes.
Read section 16. Q, Special Marriage Act. Retrospective marriage is unknown to Hindu law. Special Marriage Act. Do you have that copy? Can anybody Google up Section 16 of the Special Marriage Act?
Marriage Act.
One 6 of Special Marriage Act 1955, 80.
It is 54.
54.
Section 54 outlined that the procedure for registration of a marriage under this act.
On receipt of an application signed by both the parties to the marriage for the registration of their marriage under this chapter, the marriage officer shall give public notice thereof in such manner as may prescribe of prolonging a period of certificate for objections and of hearing any objection received within that period shall, is satisfied that all the conditions mentioned in 15 are fulfilled, enter a certificate of the marriage in the marriage certificate in the form prescribed in fifth schedule, and such shall be signed by the parties to the marriage and by 3 witnesses. No, there is no provision for retrospective marriage. Any marriage also can be registered.
They will be applied for the same. 30 days is the period. Any objection there too? After completion of 30 days, then certificate will be issued by the marriage officer.
Two things. One, you need not undergo the marriage ceremony at all. Straightway, if you register, it becomes a marriage. That is called constitutive certificate. By virtue of certificate, marriage is assumed. That's a fiction of law. There is marriage like exchange of garland or tying of Mangal Sutra, Saptapadi, Arundhati, Nakshatra, Darshana, Vivaha, Homa. All this is Shastric marriage, not Paishachik. That also can be registered under this act. There are at least 2 decisions. One is from Allahabad High Court, another is from Kerala High Court. You just look into that and come back. There are many. There is one good book also, Paras Diwan, on marriage and divorce. There is one good book. Good means fairly well. Not I can't say that good, bad, etc. But it gives an idea. This one. If suppose marriage has already taken place, it is open to you to get it registered under the Special Marriage Act. Because once it is so registered, Hindu Succession Act will not be applicable. Hindu Marriage Act will not be applicable. This is discussed by one great thinker. His name I forgot. Duncan C. Derrick. Duncan Derrick. He has written one book on that. Just read and come back. I'll also read again. All right. Paras Diwan is a good author on family law. He has written. Just look into it. Just call him. First week of 27/11. 27/11?
Probably use.
Item 50.
My lords.
Yes, brother.
This case, my lord, petitioner challenging the order passed by the collector cum chairman or annexer 10 man. Your my lord, not consider my certificate as a nationalized game, my lord. Can you glance annexer on the advertisement? Just 13, my lord.
Annex 1 is 14, my lord. This is the advertisement for selection of the PET physical education instructor, my lord. The three category, my lord. Age, educational qualification.
What type of physical education?
Education qualification are +2 with a CPD. Person having higher qualification in physical education, that is BPD and MPD, he may be eligible for the post. I am not that, my lord. I am the last category, my lord. The sports persons with having issued the ID card by the sports department of recognition the achievement in sports, my lord. The last person. In case of the non-ability of the candidates of the above category, sports persons having national level or state level participation may be considered, my lord. As per the letter, my lord,
having national level, state level participation.
All for 030 16 19 to 2013, my lord, that is the letter issued from the selection procedure, my lord. That has been annexed 5, my lord. Basing that instruction, my lord, they have selected the candidates. Can answer 5, my lord.
5. In case of non-availability of
page 28, my lord.
Yes.
This document
para B.
Para B, my lord.
The above
last mile para 1, my lord. National level sports person. Last person, my lord. This is the clarify who is the national person and who is the state person, my lord. Often in the sports participant event in the that events, my lord. Can glance last person, man. National level participation.
National level sports person.
My lord.
National level participation.
Represented state in any senior, junior and sub-junior national championship, All India Championship, All India Women Championship, All India
Rural
Championship, SGPA Championship, recognized by the Sports Authority of India, Odisha. Can glance Annex 2, my lord, the petition obtained the certificate. Annex 2, my certificate, my lord. Here, Annex 2, my certificate, my lord. Can glance page 16, my lord.
Participation certificate.
My lord. I have obtained the certificate in the event of the cycle polo, my lord.
It is issued by whom?
Issued by the recognized by the Ministry of Youth and Affairs, Sports, Government of India, Sports Authority of India, my lord. National Cycle Polo Championship organized by the Odisha Cycle Polo Association and Bhubaneswar District Cycle Polo Association, my lord. This certificate they not consider, they saying that this certificate is a not recognized game, my lord. Apart from that, my lord, kind glance
slowly. After making one statement, you should allow the listener to process it. Now make the statement. You say,
my lord,
this is Odisha Cycle Polo Association and Bhubaneswar District Cycle Polo Association under the auspices of Cycle
Polo Federation of India, recognized by the Minister
of Affairs of Sports, Government of India, Sports Authority.
My lord.
The rule says recognized by whom? By the Department of Government.
Recognized by the Minister of Youth, my lord.
Go to the rule now. You have read that letter, no?
My lord, I only read the certificate, my lord.
No, certificate all right. Go to letter now.
Letter Annex 5, my lord.
Annex 5. By whom it should be issued? Letter. The following process shall be
the only.
In addition to candidates having +2 qualification, persons having higher qualification, that's not fine.
They have not disputed my
non-availability of candidates of the above category. The following procedure shall be followed for selection of candidate from among the sports persons. In order to prepare ranking of former sports person from the available applicants, the following criteria may be adopted. Represented state in any senior, junior, sub-junior, national championships, All India Women Championship, All India Rural Championship, SGFI Championships recognized by Sports and Youth Services Department, it is perhaps. Yes. Department, Government of Odisha, in which you fall. Your certificate fits into which?
Annex 2, my lord, issued by the organized by the state, my lord. That national participation is organized by the state, my lord. But they said that my certificate is not approval game, my lord.
I am also feeling like that now.
No, my lord. Basing similar matter, my lord, they have engaged the can answer 11, my lord. Same certificate, same sports, my lord. They have given the appointment or the district, my lord. Okay. Can glance annex 11, my lord. I have already attached 2 persons that having same qualification, my lord, same certificate, same advertisement, my lord.
They have given.
Your lordship know this Lolita case and the Krishna Bhatto, my lord. They should not discriminate that matter, my lord. And the coordinate bench also on that light had passed, my lord. I have given that judgment, my lord.
Yes, sir, Brother Lenka.
Yes, sir.
How can you discriminate?
How can they discriminate?
One set of people.
Para 21, my lord. Here, my lord.
That his case is that not to maintain parity. That's all one aspect. Another aspect you also can see that Annexure 5. I'll take your lordship page 28 once again. Annexure 5, 1. That your lordship just now read.
Yes.
That's last 3 lines from bottom. Recognized by the Sports and Youth Service Department, Government of Odisha.
No, that is comma is there.
Yes.
Kindly go to comma we have it. No?
My lord, here, my lord, those are.
In senior, junior, sub-junior, national, all India Women Championship, all India Rural Championship, SGFI. This SGFI means what? State
Federation of India.
State, what is G? State Golf Federation of India. No, it cannot be like that. SG means what? School Games Federation of India. You are right. That school games are concerned, state will recognize. For rest of the people, state recognition not necessary.
Yes. And the certificate, Annexure 2, that certificate says recognized by the Ministry of Youth Affairs and Sports, Government of India, Sports Authority of India.
Then again your case is worse now.
That is the certificate.
Understood. Then it makes your defense useless.
And your lordship will find that he has also annexed that in similar circumstances.
Similar circumstances, the same certificate is acted upon. It have been engaged. Why not this person? Perhaps this person has not paid something. Take down. Kindly be seated. Petitioners candidature for appointment for engagement as physical education instructor. Kindly be seated. PT instructor having not been considered, he is complaining before the legal court. First up, learned counsel for the petitioner draws attention of the court to the impugned order dated. Just show that. Which is at Annexure.
Annexure 10, my lord.
Annexure 10.
Impugned order, my lord.
Go to 10. An order dated 22/11/2024. At Annexure 10. Which is structured on the premise that the sports certificate at Annexure 2 does not answer the requirement of letter dated. You said that letter, na?
19 to 13.
Dated 19 to 2013. A copy whereof avails at Annexure 5. First off, he submits that the impugned decision is vitiated in as much vitiated on 2 grounds. One, small Roman 1. the sports certificate at Annexure 2 answers the required description in terms of letter at Annexure 10. 10?
10 is rejection.
Annexure 5. Annexure 5. 5. And secondly, others we have got identical certificate have been benefited by engagement of their services. First, council presses into service Apex Court decision in KI Shuffled versus Union of India, AIR 1988 SC 686, to the effect that his client has been stepmotherly treated at the hands of answering OPs. Next paragraph. Learned AGA, Mr. Lenka, appearing for the OPs, opposes the petition, contending that the sports certificate in question does not answer the required description in terms of letter dated so and so at Annexure 5, 13. Secondly, even if others have been granted the engagement on the basis of similar certificates, there cannot be parity and equality unless what has been done to others is shown to be legal. First, next, having heard learned counsel from the parties and having perused the petition papers, this court is broadly in agreement with the submission of learned counsel appearing for the petitioner that the sports certificate at Annexure 2 should satisfy the requirement of the advertisement, which reflects government letter dated 19/2/2013 at Annexure 5. At Annexure 5. First, the question of recognition by the state government would not arise, since the sports certificate in question falls in different category, enlisted in the said letter itself. First, next paragraph. Learned counsel for the petitioner is more than justified in pressing into service the Apex Court decision in Shuffled Supra, to the effect that similarly placed persons should be similarly treated, and this similarity bruises the soul of Article 14 of the Constitution of India. First, no explanation is offered by filing the counter as to how, in respect of other similarly circumstanced candidates, identical certificates have been acted upon for the engagement. First of all, similar cases should be treated similarly is the golden rule of equality. As observed by the Apex Court in EP Royal Powers State of Tamil Nadu, like AR 1974 SC base 555. First, in the above circumstances, this petition succeeds. Semicolon. A writ of certiorari issues, quashing the impugned order dated so and so at Annexure 10. Semicolon. A writ of mandamus issues to whom?
OP 2 and 3, collector,
OP numbers 2 and
chairman,
3.
and the DPC.
To positively consider case of the petitioner for engagement as a physical education instructor
on a national level, on a national participant.
Treating him as having the requisite sports certificate, which is at Annexure 2. First off.
As a national game. As a national game.
Whichever is there.
They are not treated by national. If they
into brackets. National
level participant.
National level participants. Okay, complete. This should be done within a period of 8 weeks. 8 weeks. Failing which, at the next level of the litigation, heavy costs in thousands of rupees may be levied on a personally payable by the erring officials. Yes.
Item 51.
Okay.
Madam, notice has been issued, my lord.
I need that judgment.
No, sorry. I will only.
The notice has been issued, my lord, but they have not filed the counter, my lord. Fact of the case is like that, my lord. Initially, the petitioner was engaged as a Shiksha Sahayak, my lord. File is continuing as Shiksha Sahayak, my lord. A small child was died in electrocution. FIR has been registered against, my lord, headmistress and other teachers, my lord. Subsequently, as I am a Shiksha Sahayak, my lord, notice has been issued. Now, before filing of the show cause, my lord, they have dismissed from me from my service, my lord, as Shiksha Sahayak. Subsequently, I have challenged.
One second. Full stop.
My lord.
How many kilometers your house is from the court? No, in the full gear, bike or car?
Sorry.
In the fourth gear only you will come. Or you will change the gears. You will change the gears. Yes. Make one statement. Stand for a while so that the listener will assess it. Okay? That is argument. Yes. Now make statement from beginning now. First sentence.
Madam, initially the petitioner was engaged as a Shiksha Sahayak.
Shiksha Sahayak.
My lord. While he was
when he was engaged, so
engaged, my lord.
Date of engagement is? This is only to hurt you.
22/3/2011. 22/3/2011.
22/3/2011.
My lord.
Then what happened?
While he was continuing as such, my lord, he was deputed to another school from 10/9/2014 to 17/9/2014.
10/9/13 to
17/9/14. Deputation to another school.
Few days.
My lord. On 17/9/2014, my lord, a student was died in electrocution in previous school, my lord, while he was there, my lord, initially.
You were not there at that time?
No, my lord. He was deputed in another.
You were on deputation to another school?
Another school.
And now they have lodged the complaint with you against you also?
My lord, against the headmistress and other staffs of the school, my lord.
You are what?
I am a Shiksha Sahayak.
You are also staff?
My lord.
Against you also?
My lord.
On what ground? How? Wholesale electrocution or what? One boy is dead is all right. It should not happen. But how this person is concerned with that, Mr. Lenka?
No, that he is not correctly placing his fact. He has, it was found, and she had a vital role regarding hooking of electric wire, live wire, and for which the girl, while going to urinal, get touched and died.
But during that period, she was in.
No, she was.
No, 10/9/2013 to 17/9/2013, she was on deputation to another school.
No, that
Annexure 3, my lord. Annexure 3, page 24, my lord.
Annexure 3.
My lord, page 24.
This is issued by block education officer.
My lord.
whether any police complaint police cases happened.
My lord.
So whether you are set up for
police submitted final form as a police submitted final form, my lord. Final report, my lord.
Final report.
My lord.
173(8) of CRPC.
My lord.
Saying it's a mistaken of
Mistake of fact, no one responsible for death, my lord, and that has been accepted by court.
Informative B report is filed.
Yes. Thereafter, she was reinstated. Now she has come before our lordship claiming the period she was out of, she was disengaged. That period she wants salary and other service benefit.
Right, salary you may not give, at least the service benefit you have to give, na?
Yes, that your lordship.
And the decision is also stayed by the Hon'Ble, my lord. But they are not allowed to work, my lord.
Page 68, your lordship will see. Page 68.
68?
Yes.
Of disorder. Take a decision in the matter of in terms of observations made in earlier WP order.
Yes. Your lordship, I'm last just two paragraph I'm placing.
WP. This is second.
Considering the situation, Collector cum DO Jilla Parishad Balasore has been pleased to pass order to treat the matter as per rule. It is pertinent to note that Srimati Biswal was working as a junior teacher on contractual basis at the time of disengagement and not a regular teacher when the incident took place. The junior teacher are regularized after completion
of 3 years of continuous satisfactory service. Had she continued in the post of junior teacher for 3 years with satisfactory performance, she would have been regularized.
Yes.
But what is her fault?
Then your next para. Hence, she didn't complete 3 years of continuous and satisfactory service to claim the service and financial benefit for the above period. Hence, the period of disengagement from by 21/10/14 to 19/7/23 will be treated as the period of no work, no pay, and she will not be entitled to get any consequent service and financial benefit.
The last sentence is wrong. She may not be entitled to wages.
But to service.
But service she is entitled. It is her fault. Where is the charge sheet against her? Police have filed the final report and you have accepted.
She had approached earlier twice. Your lordship, page 55. A lengthy judgment has been given.
Kindly glance to page 47.
One second. I'll come to you.
Page 55. Last, a lengthy judgment has been given by the coordinated bench of this court.
Length of the judgment will not do justice.
No, that your lordship see.
The judgment may be very long and the person may be hanged out.
Paragraph 9.
Not be sure.
Your lordship, paragraph 9 at page 58.
Per contrast, so argues admit residing in the school as per a preliminary fact finding, she was found to have played a role in
hooking the electric line, which ultimately led to mishap resultant in death of the child. How can she deny now?
No, where have you held the?
She has no role.
No, where have you held the inquiry? This is your argument.
No.
Kindly see, per contra, Mr. Bipin Mohanty argues that the petitioner was admittedly residing in the school. That is your argument.
Argument that she had a vital role for that.
Where is the inquiry?
Then Shokaz was, that has also been dealt in that judgment. Shokaz has been called for. Twice time was allowed to give an explanation and she didn't give.
She did not give all that. You should have held the inquiry ex parte. Suppose you send a Shokaz notice to me.
Yes.
Saying that you have committed XYZ to misconduct. He will not reply. Have you said in the Shokaz notice, if you do not reply, we will deem that you have committed it. It's a serious charge. The life of a boy has gone. Very serious charge. Why did you not hold disciplinary inquiry? Only exchange of letters will not help.
FIR was lost and the police took up the investigation.
And police said no case is made out against her, against anybody.
Anyway.
As if God has committed the murder of that boy.
That is the for that the collector reinstated her.
You have reinstated. That may be good on your part, but where is the counting of service given? If you had given counting of service, her services would have been regularized along with others who are juniors to her.
That you not. That you not sure.
Take down.
But not entitled to because she has not worked.
So that all right.
As because my lord,
You are not, if you agree that you are not entitled,
the dismissal order has been stayed, my lord. This dismissal order has been stayed by the Hon'Ble Court, my lord. Your lordship kindly glance to page 47, my lord.
Stayed.
My lord. But they are not allowed, my lord, to work, my lord. Subsequently, decision was set aside and the Hon'Ble Court remitted the matter for fresh consideration to the collector, my lord. Collector re-engaged me, but no financial benefit and service benefit has been given, my lord.
Will give you service benefit. Financial benefit very difficult. So many things have happened there.
My lord.
You may be away in school, but having put a live wire there, if you were there.
But I have been acquitted, final report has been submitted, and the discharge order has been stayed, my lord. But they are not allowed to work, my lord. In your lordship, must have been on the judgment of Janak Jamarma. If employee is interested and employer not allowed, my lord, he has to give him all service benefit, my lord. Financial and service benefit.
Oh, there are so many cases happening.
Your cases you have been prevented from working.
Working, page 47.
Despite stay order.
Stay order.
There was interim order, Mr. Lenka. You did not obey that. For disobeying, you want to benefit. How can that be? He is right in telling that now. Because the disengagement order was stayed. Immediately you should have reinstated her. You did not do. Ultimately, whatever happened, happened all right. But where is fault on her part? Have you kept that wire alive even now? Or removed? You should have brought those officers to that place instead of that boy. They should have made to touch it. Take now. You have to make 50%. Pay 50%. Petitioner, kindly be seated. Was terminated from service on the ground that she was responsible for the electrocution of a schoolboy. Schoolgirl. Who eventually met her maker. First off. That termination was put in challenge in WP number 21988 of 2014, and a coordinate bench of this court had granted interim order of stay. First off. A police investigation also followed, resulting into no case being made out against anyone for the accidental death of the school girl. First off. Thereafter, the said petition came to be disposed of by the order dated 20 January 2023. Is it right? No. 23. Remitting the matter back to the portal of collector to take decision afresh in the light of certain observations made in the course of judgment. First up. Next paragraph. The collector or district education officer?
District education officer, my lord.
But the direction was to the collector.
My lord. On behalf of collector, he has, my lord, re-engaged, my lord, Annexure 12, my lord.
The district education officer, while having conducted the remand, carried out the remand, made an order dated 20 July 2023, whereby petitioner was re-engaged in the service with the same terms and conditions of OSEPA full stop. Thereafter, petitioner has been working as a junior teacher, correct?
My lord.
Junior teacher in KB Government UP School, Patimunda. First time. Next paragraph. Learned counsel for the petitioner vehemently argues that the impugned order to the dated 14/8/2024, 14/3/2024, to the extent it denies the monetary and the service benefit during the period when she was away from service is vulnerable for challenge, inasmuch as though there was an interim order in the earlier round of litigation staying the termination, she was unjustifiably denied engagement. Full stop. Next paragraph. Learned AGA Mr. Lenka, appearing for the OPs, makes a submission in justification of the impugned order, taking the court through some observations made in the judgment of the coordinate bench in the earlier round of litigation launched by the petitioner. First off, he contends that for the death of the girl child, petitioner is responsible, and therefore no relief can be accorded to a culpable litigant like the petitioner in writ jurisdiction. First off. Next paragraph. Having heard learned counsel for the parties and having perused the petition papers, this court is inclined to grant indulgence in the matter as under and for the following reasons. Number one, death of the schoolgirl is not in, unfortunate schoolgirl is not in dispute. The child died because of electrocution is also not much disputed. First off. However, after the police investigation, none is set up for trial, the charge sheet having not been filed in the absence of evidentiary material. First off, only B summary, capital B summary was filed under the provisions of section 173 of erstwhile CRPC 1973, making out no case against anyone, much less the petitioner. First off. Therefore, dislodging of termination order is absolutely justified. First off. That being said, it is ununderstandable as to how back wages, at least in part, and the back service can be, and the notional service can be denied to the petitioner who had obtained interim order of stay at the hands of this court against the termination order.
The order, disengagement order was passed on 21/10/2014. And the
21/10/2014. Correct.
And the interim order passed on 13/11/2014. By the time already.
No, thereafter you should have taken him. This is what which is that famous judgment. That Chamundi Moped versus so and so. Take out that judgment.
And he was a contractual.
Whatever it may be. Chamundi says, in Chamundi Moped versus, can anybody take out that judgment? When once a stay is granted by the court, the party should act upon that.
After implementation.
You have to implement that. Even after implementation. That's the judgment. The argument was, already we have relieved that candidate. There the Supreme Court said, if you had relieved, why did you not take them back after the interim order of stay was granted? Then they argued there was no direction to take back. Court said, don't say all that story. Take out that judgment. Chamundi Moped versus
Mr. In the present case, the interim order allowing the writ application.
Subsequently, writ petition is allowed is another thing. But you get that judgment.
The Chamundeshwari Electric Supply, Civil Appeal number 688 of 2018.
No. Chamundi Mopeds versus Swine Law.
Church of South India.
Chamundi Mopeds
versus Church of South India Trust.
Correct. First one. Next paragraph. Ordinarily, when a termination order is stayed by the court or competent authorities, the termination is kept under suspended animation and employee is entitled to be put back in the earlier position, subject to outcome of the main decision. First off, this view gains support from the Apex Court decision in Chamundi Mopeds versus Science. Just look into that. Can anybody tell which paragraph? Just look into it. Ask the person to bring my notes. Where is the Jamedar? Ranjit? Bring all 4 volumes. Just look into those notes. Do that, okay. From Karnataka High Court, get to Supreme Court. Yes, just look into my notes and write down. Yeah. When employee was ready and willing to work on the basis of the interim order of the court, writ court, comma, there is no justification whatsoever for denying the benefits of back wages and service. Order quashed, order stayed. Under that heading, find out. First one. An argument to the contrary would amount to placing premium on the illegal act, unlawful act, on the culpable act of the gopis who prevented the petitioner from serving in the institutions, whatever be the status. First stop. Next paragraph. In the above circumstances, this petition succeeds. The impugned order, to the extent it denies back wages and notional benefit of service, is quashed, comma, retaining the rest. Next paragraph. In the fitness of things, a writ of mandamus issues to the OPs to count notional service of the petitioner when she was out of employment, and further to grant 50% of back wages to be calculated reckoning the date of interim order, that is 23, that is 13/11/2014.
Yes.
Secured in WP number
21988.
21988. 21988 of 2014. Within 8 weeks. Further, all other benefits which candidates immediately junior to the petitioners have been granted, such as regularization, etc., should also be extended to the petitioner within 3 months. First up. Next paragraph. It is a...
Can I interrupt? The service of the petitioner was a Shiksha Sahayak manner.
Correct.
So if they were not getting wages, they were getting certain emoluments.
Instead of wages, stroke emoluments. 50% of emoluments.
Whatever.
You're right. But once we say wages, many other consequences will follow.
And simultaneously, your lordship said notionally. that may not be applicable.
No, that will be because for regularization you count the service.
Counting of service will be
6 years. 6 years.
6 years.
So
far,
he will not get that also.
Yes.
so far as notional benefits, he will not get any increment.
Notional service.
Notional service.
Notional service only.
Notional. I have seen notional service.
But he has to render 6 years of service
to get regularization.
in the capacity of Shiksha Sahayak as well as junior teacher.
Both junior teacher.
Both. After 3 years, he becomes a junior teacher. And thereafter,
Another 3 years,
he become a regular private.
he becomes entitled to
regular teacher.
Service, that's it.
But your
Notional service. Notional service.
issues.
Increment would have been
Out of employment for the purpose of regularization on par with other similarly circumstanced candidates and further to grant 50% of the emoluments,
They are not getting any other service benefit.
no other service benefits. Record from 13/10/2014. Correct. Entry model is 13/10/2014.
11.
11?
Yes.
No.
13/11/2014.
13/11/2014. Secured in WP number so and so. Then in a wholesale way, but time for compliance 3 months. 3 months. Okay. Yes. Yes.
Pardon to mention in item 49, there is item 49, there is interim order matters.
49.
49.
Interim order to continue.
Item 52.
Yes, sir. Other matters I may not take. After this, I am likely to raise. For other matters, do not wait. Do not mention also. Yes. Yes, sir.
Here, my lord, the petitioner challenges the inaction of the opposite parties in not paying him the gratuity.
Not paying the gratuity.
Gratuity. Here.
You are in employment during what periods?
My lord, your lordship can peruse at page 15. The detailed description is there.
15.
Page 15. The petitioner appointed on 25/6/2007, man. He worked up to 26/12/2023.
Then retired on
not retired, left the job on the resignation.
26/12/23.
Yes. The relief order in the page 14. The relief order. Page 14 is the relief order. On his resignation, he was relieved. (26/12/2023).
Have you got that judgment of the apex court? One matter went from Gujarat. Can you look into and bring that? It's in your favor.
I can.
Yeah.
I can.
For this matter on 28/11.
28/11.
Yes.
Gujarat High Court. I can bear. Here they have
to that and bring that judgment.
Your question remains, my lord. Sorry for the interruption, man. Initially, they said that you are not entitled. Subsequently, another letter was issued that an inquiry is going on against you. So, your application can be considered after completion of the inquiry. After 15 days, another letter was issued that since you have submitted an application at a belated stage, it cannot be considered. 3 letters I have annexed. And during pendency of the writ petition, though my learned senior who is appearing for the other side, he agreed to settle the issue and we both...
For others, I am not. Anything can be done in the matter.
But
The petitioner has been appointed on consolidated salary. But some calculation has been made and that has been transferred to the.
Give it to him.
Yes, but
And then he will,
the petitioners are not agree.
not agree.
But why not agreeing? I am submitting that. Your lordship knows that in a consolidation,
Calculation.
Can you share copy with me?
I can give it with
Yeah. Some settlement there is in which is that
now what they say, they have agreed that I am working on consolidated wages. Consolidated. Sorry, my lord.
Your lordship may call this matter Monday. I will call for the.
I am unable to find out. It is with me.
there is a shloka, Bhartruhari's Niti Shataka, which says, Vinashakale samutpanne ardham tejita panditaha.
Yes.
When you are losing everything, one who says half is the wisest of all. No, I'm not saying you are losing, I'm just saying, see, go on battling. Go on battling will not help in life. I tell you the truth.
But
some adjustment, some compromise.
I am ready to adjust, my lord. What they say, that your lordship knows in a consolidated salary, house rent allowance is not included. Now they said that we will deduct house rent allowance as 28,000 per month, and it will be deducted in this ratio, it will be deducted from your gratuity. So when I was working on consolidated salary, how can you deduct house rent allowance? And they have filed the tax return, IT return, that there is no house rent allowance, showing that. That document is with me.
So he is threatening you now. He may go to income tax department now.
No, that document is available in the website. I have got that document.
Anyway, just look into, ask your university to stand tall, consistent with its structure.
I said them that I can negotiate with the interest. I will not charge interest. But
see, sit and negotiate. Sit under the shadow of a big tree, banyan tree.
For a losses kind company. I had accompanied with my learned senior to the university.
Well, we grant one more chance so that the matter can be settled.
Very good.
So that is
but
why
make some effort. Tell the university to be fair, tall. University.
Fairly, I have expressed my opinion that we will not claim any interest because the Act clearly says the
interest is payable.
Yes. I have said that I will not claim any interest. You pay
all the claims has been settled except that two.
That 2811.
Mine.
In the meanwhile, you make some research and come back.
Mine.
Okay?
Yes.
We have one program today. Centenary program we have.
Item 53, just next item. I pray in Lordship Committee first week of November because to file a counter.
Second week of November?
Yes.
Second week of.
My lord, serial number 57. Already your lordship settled the issue, my lord. In case of Lutiware and others versus State of Odisha, my lord. The case was posted today, that is the covered matter, my lord. Next week that will be posted.
Is it covered matter?
Yes, my lord.
Who? Other side?
Your lordship's past order, my lord.
Who appears for the other side?
I'm there.
Mr. G, just look into that order.
Yes.
If it is covered, why next week? We will say matter is covered.
Yes.
Give a copy to Mr. G.
So, issue is, my lord, whether senior reserve category candidate can be considered against unreserved vacancy merit for promotion, my lord. I am senior reserve category candidate according to gradation list, my lord. I may be considered against.
To check it up, my lord.
Already,
My lord.
last again,
It requires because the reservation.
Because it will have some consequence.
Yes, my lord.
2611
yes. Sudden.
or 1211?
12,
my lord. My lord.
12.
Yes.
Item 54, my lord. Taken up next week, any date, my lord.
Then what is the urgency? Next week, then the vacation, the holiday begins, na?
No, my lord.
You don't celebrate Diwali?
Next week, no holiday.
Diwali.
Next week, no holiday, my lord. Direct.
Week after next it will be. Next week we have already posted a bunch of matters.
Then 27 week come 27.
27
October man.
October. But keep it on 30th.
Item 56 Accident matter yes accident matter this month
if that also on 30th.
Item number 55, sir. Please kindly take up.
I can't see you. Which date you want?
Senior is gone outside. Please kindly take up 13.
13.
Next
15th. We have difficulty.
Sir, 14.
No, that week we have difficulty. Give one more adjournment to me.
Sir, 22. 22.
22nd. All right. 22nd. What's your name?
Surya Banu.
Surya Banu. Anybody? Okay.